Devesh, I think you are on mute.
पुनीत का स्पेलिंग क्या है?
PUNIT, sir.
अच्छा, ठीक है.
Sorry. So, good morning, everybody. Today, our group will be presenting a case study on one of the most prominent patent infringement cases in our country, Bajaj Motors versus TVS Motors in 2007. Now, this more than decade-long case first began with Bajaj filing a patent infringement case against TVS when in 2007 TVS launched its Flame series with the CCVTI engine, which Bajaj claimed has infringed its patent of DTSI engine with twin spark engine. Now, this presentation, we shall be answering, giving information about the two engines, the facts of the case, the court proceedings, and the most prominently justifying the importance it carries in patent infringement cases in our country. So let's begin with the two engines.
So we are going to discuss the two engines here. So the two engines that we are discussing are DTSI, which stands for Digital Twin Spark Ignition Technology, and the second one being CCVTI, which is Controlled Combustion Variable Timing Intelligent Technology. So Bajaj Auto Limited came up with the DTSI first up, and they were granted Indian patent in respect of a patent application titled an improved internal combustion engine working on four-stroke principle. The said invention relates to the use of twin spark plugs for the efficient combustion of lean air fuel mixture in small bore ranging from 45 mm to 70 mm internal combustion engine working on four-stroke principle. So Bajaj developed DTSI engine which has two spark plugs placed symmetrically to the axis at 90 degrees each, making a 90-degree angle with each other to the to the valve axis. So they are present at a 90-degree angle inside the cylinder, and thereby giving the two spark plugs the ability to control the ignition in two halves of the chamber. The advantage of using two spark plugs can burn is that they can burn the air fuel mixture much quicker with comparison to the single spark plug, and all of this gives a greater efficiency to the engine. Next, moving on to the TVS Motor Company Limited engine, which they came up with, which was TVS Flame. So, TVS Motor Company Limited launched motorbikes of 125cc under the trademark Flame, powered with a lean burn internal combustion engine of bore size 54.5 mm with a twin spark plug and three valve configuration under the name of CCVTI. Using three valves results in increasing the valve area within a cylinder, and all of this helps in equalizing and minimizing the flame front path in any direction, thereby resulting in an increase in overall vehicle efficiency and increase in power of the engine.
Okay. So, in 2007, Bajaj claims patent infringement against TVS at Chennai High Court, and in response to that, TVS files a suit before Madras High Court, claiming that Bajaj is making a groundless threat of patent infringement. Next. Yeah, so the arguments so the arguments that came from the Bajaj regarding this technology was that they have an improved internal combustion engine working on four-stroke principle having two valves per cylinder. They also claims to have an improved cylinder wherein a pair of spark plugs were fitted subsequently diametrically opposite to each other, and the fixing means in their engine is a circlip or a screw. Now let's understand the patentability of the inventions that Bajaj claims to have. According to the plaintiff, they had invented a unique technology of using two spark plugs for efficient burning of engine air fuel mixture in a small bore engine, which lies between the size 45 mm to 70 mm. The thing is, in small bore non-engine race, in non-racing engines, the need to have more than one spark plug was never thought necessary. The invention was on the application of twin plugs in small ball engine, a specific engine running condition of lean burn, to derive positive merits of improved fuel efficiency and emission characteristics. The novelty of this engine lies on the use of lean burn engines, and also the industrial application lies in the fuel efficiency. This helped the automobile industry in cutting short the fuel consumption. Now let's understand the TVS response in this case regarding the Bajaj's arguments. So the following arguments were made by the TVS regarding the case. The TVS argued that the concept of two spark plugs was already been published in various research papers, and there were already existing patents in various countries like USA under the name internal combustion engine with dual ignition for a lean burn. They also said that companies like Takigawa Cylinder Heads and Honda Bros are already working and already configuring same kind of engines which have two valves per cylinder with twin plugs. The fourth and the final claim that was made by the TVS was that their technology is already uh, protected by the patent license to them given by AVL list GmbL. So these were all the responses that TVS made in response to the Bajaj's claim regarding the patentability of their technology. Now handing over to Anup for the next slide.
Right, thanks, Puneet. So, having starting this tussle in 2008, Bajaj, the Madras High Court actually ruled out in favor of Bajaj itself by restraining the TVS from launching its new flame technology, and they claimed that the Bajaj has claimed itself as a prima facie and was able to defend that. Apart from that, regarding the inventiveness in the technology, they did conclude that there was a technical advancement as compared to the existing knowledge, and also that it had economic significance. Having said that, the Madras High Court single bench ruled in the favor of Bajaj itself. Moving on. Uh, have aggrieved by this decision, TVS decided to move a bit higher, and they finally decided to approach Madras High Court's division bench, which finally, after long discussions, finally decided in removing the stay that Bajaj, the single bench had over the TVS, and they finally allowed TVS to move ahead with its selling of the flame engine. The decision was based on the fact that the Bajaj was not able to claim itself as a prima facie, as because both of these engines were based on the different virtues. While the DTSI engine worked on the virtue of twin spark plugs, the TVS engine worked on the virtue of receipt of the air fuel mixture through different intake valves. So their points of emphasis being considerably different made allowed the decision to be in the favor of TVS itself. Moving on. Again, aggrieved by this decision, the Bajaj again went on to the largest court in India, that is in Supreme Court in 2009. They appealed before the Supreme Court, which analyzing both the decisions of the previous two courts as well as the hearing the pleas of the defendants as well as the like both the TVS and Bajaj ruled out that TVS is entitled to sell its motorcycle flame, but it shall also maintain the alternate accurate record of entire domestic and internal sales. It also ordered Madras High Court to appoint a receiver in this connection. Moving on. Right. So finally, after this decade-long tussle ended in October 2019, when TVS and Bajaj they settled their issues amicably. They finally decided that no longer they do not have any kind of pending legal activities, or they do not need to pay penalties to each other, and finally concluded this case. So this picture here gives a brief timeline of the patent infringement case that happened right from 2007 to 2009.
Why do you call it landmark judgment?
Devesh, you are muted.
नहीं, ये सुप्रीम कोर्ट का क्या है? ये थोड़ा सा दोबारा बताना है, क्या है सुप्रीम कोर्ट वाला?
Right. So Supreme Court finally ordered that the both of these the flame motorcycle that was TVS's product is finally allowed to sell, and but it's that it has to be accounted for every sales that they did, as well as the Madras High Court to be legally responsible for handling this situation by putting in an intermediator.
Okay.
So now this case prominence lies in the Supreme Court proceedings. Now, in its interim order, the Supreme Court reiterated that in matters relating to trademarks, copyrights, and patents, the provisions of Code of Civil Procedure, which mandate that civil disputes should be heard on a day-to-day basis in all courts without any adjournments, except in circumstances beyond the control of the parties. Now, this ensured quick and firm judgments in all court proceedings in relation to trademarks, copyrights, and patents. Now, this sought protection to industries and promoted them to invest more in research and development, and it protected their returns on their research and development, and this promoted globally research and development increase in research and development in India. Thanks.
Where is your thank you slide?
Sorry.
Thank you.
थैंक यू स्लाइड भी डाला करो एंड में भाई. हाँ
Sorry.
हाँ
Okay.
चलो. थैंक यू.
Thank you, sir.
Next.
So group number 8. Group number 8. Please start your presentation.
Okay. 15 नहीं आया अभी.
नहीं sir.
Okay. ईशान.
Yes sir.
एक एक है ना इनका जो भी ये प्रेजेंट कर रहे हैं ना.
Yes
तो
sir.
एक बिगनिंग में एंड में कभी भी इनको सबको एक अपना फोटो वीडियो ऑन करें और सबका एक स्क्रीनशॉट लेते रहो सबका.
Okay sir. Sir, it is already recorded sir. ये रिकॉर्ड हो रहा पूरा.
अबे रिकॉर्ड को कौन देखेगा? स्क्रीनशॉट ले लो ना सबके फोटो का.
Okay sir. Okay.
इजियर.
Okay sir. Okay sir.
कहाँ है ग्रुप नंबर?
Group number 8. Where is group number 8?
9 10 कोई कौन है इसमें? कोई भी नहीं है क्या?
Group number 14.
Yes, sir.
Start your presentation. Group number 14.
Okay, sir.
बासमती बॉर्ड्स. हाँ.
Yes, sir.
गुड.
See, is my screen visible?
Yes, your screen is visible. Please
कंक्लूजन दिखा रहा है
maximize
ना
it.
अबे. कंक्लूजन दिख रहा है मुझे. हाँ, एक मिनट.
No, sir. I have gone into full screen.
अच्छा एक मिनट.
No, it is not full screen yet.
If you press F5 it will come on full screen. हाँ नहीं अभी नहीं हुआ. चलो.
And please switch your camera on. All the four.
So now is it full screen?
Yes,
yet.
it is full. Yes, no, not full screen.
आपको जो लेफ्ट में सारे स्लाइड दिख रहे हैं ना,
Okay, sir.
ये बंद हो जाएंगे जब फुल स्क्रीन आएगा तो ऑटोमेटिकली. ठीक है. F5 को प्रेस करोगे फुल स्क्रीन में आ जाएगा.
I'm pressing on F5, but
चलो कोई बात नहीं. चालू करो.
On top, next to the undo button, click on that. On top, yes. That on the left of the arrow.
लेफ्ट ऊपर एरो किधर वही
डिजाइन के ऊपर.
so now it's full screen.
Not yet.
Not yet.
इसको जरा करके देखो. Enable
Go in
editing
the
को करके
enable
देखो.
editing mode. Enable editing mode.
Enable editing करो, फिर उसको करोगे हो जाएगा.
You have shared a window and the slideshow starts in another window. So the
So now,
slideshow is not visible.
now is it full screen?
Nothing is visible now.
So maybe someone else can present, Asher or someone.
उस वाला जो अभी क्या था उसको क्लोज करके दोबारा चालू कर लो ना.
So wait, I am downloading this as PDF and then I'm presenting it.
अच्छा कौन अभी रेडी है इस समय? Which group is ready for presentation?
We are group. Good morning, sir. Sir, we are group number 15. Gayatri and the
हाँ
team.
चलो group number 15.
Yes, sir.
15 का हाँ number 5 is हाँ.
Okay.
हाँ serial
Yeah,
number 5.
I will share the screen. Can you see the screen?
If you can make it full screen.
Yeah.
If you can, otherwise it's okay.
Yeah. Okay.
And one thing, please switch on your cameras during presentation.
Sorry.
Those who are present.
Okay.
My camera is on, and shall I start?
नहीं तीन लोग हो ना, 4 लोग हो.
We are 4.
हाँ तो चारों अपने कैमरा ऑन कर लो ना, एक बार वीडियो ऑन करो चारों. हाँ अब चारों दिख रहे हैं ना, बिल्कुल ठीक है. चलो
Should I start?
yes.
Okay. Good morning, all of you. This is Gayatri, and we are a team of Gayatri, Lokesh, Sokalingam, and Abhishek. We will be talking about the famous case of famous infringement case, Apple versus Samsung. Lokesh, how do I move to the next slide?
I will move it.
Okay.
आप वो security guard में deposit कर सकते हैं?
Because I don't see the tabs where I can move it forward. So if you can do it for me, that will be great. So we will be talking about a little background about the case before we start with the details of the case. It was year 2007 when Apple had launched its first generation of iPhone. These were as exclusive and exotic as Apple's reputation. It was a status symbol even then in 2007, and it was a coveted possession. But matters complicated when in 2009, Samsung released its smartphone and it looked so similar to Apple. Before fighting it out in the court, Apple tried striking a deal, but Samsung declined to the same. And at this point, let me tell you, Samsung has been, even now has been exclusive supplier for Apple's display systems. So supplier turning into rival was not only it went against commercial interest, but also like prestige issue in the market. So next slide, please. No, the legal battle, the one which has legal battle, it's before it. Yes. The legal battle, yes, this one. So the legal battle started it started on April 15, 2011, when Apple decided to go against it and go against Samsung for infringing its patent. These were mainly design patents and one or two three utility patents. But all the fight mainly was at the heart of the issue was the looks of it, because before Apple coming out with its iPhone series, phone looked completely different. We'll see it in the next slide.
Gayatri,
Yes, sir.
देखो, you also tell people जो यहाँ पे सुन रहे हैं कि डिजाइन पेटेंट इज नॉट ए पेटेंट. यूएसए में डिजाइन को डिजाइन पेटेंट बोलते हैं वो लोग.
Yes, sir.
मैंने बताया था ना बिगनिंग में हमने क्लास में कि
Yes.
डिजाइन जो होता है बाकी कंट्री में डिजाइन बोलते हैं, इंडस्ट्रियल डिजाइन, यहाँ पर डिजाइन बोलते हैं, पर यूएसए में कन्वेंशनली वो फॉर पास्ट few hundred years they are calling it design patent, but it is
Yes.
not actually a patent, it is just the design, but they call it design patent, so that माइंड में सबको क्लैरिटी हो कि ये it is not a patent. आउटलुक की बात कर रहे हैं ना बार बार में,
Yes,
so it
sir.
is only the design. ठीक है, but they call it design patent. Continue please.
So I'll keep that in mind, sir. Yes, sir. So now Apple had on April 15, 2011, the legal battle started when Apple had filed a complaint against Samsung. Soon it spilled over to around 20 countries and 50 lawsuits. And by end of the year 2012, it was in 50. The battle was, this lawsuit was fought in around 50 countries. And every time Apple filed a case, Samsung would retaliate and it will file a counter case against Apple. Next slide, please. So now we can see how similar these phones are. The one on the extreme left is Apple's, and the rest all are different. And it was not one model which was accused. There were different defaulting models from Samsung, which were accused of infringement. So they really looked very similar. There was overwhelming similarity between the looks of two. Next slide, please. Apple's allegations. So these are some of the Apple's allegations, but to put them in a very simple or in maybe in a line or two, it was mainly about the looks of it or the design of it. If you can move on to the next slide, please, Lokesh. Yes. So now this makes it very obvious, this slide, that phones which were, the first picture is about the phones before launch of iPhone or Apple's phone, and Samsung's Tab before launch of Apple series. And after that, we see how similar they look after the launch. So these are the design infringements which Apple accused. I have used the word patents because they use it like that way, but as sir has corrected me, we will simply use the word design. So these are
and also one thing, that the patent, when it start with D, it is a design, design patent. D.
Yes. So I'll correct it also in the slide, sir. So these were the infringements.
It is already, you have given the numbers starting with D. That means it is a design patent. That means it is design. Okay.
Yes, sir. So here I have numbered the complaint. These were the patents which were infringed upon, and I have given them as numbers. But as in the previous slide, I have already told you, or if we have to simply put it, it was more about the looks, the elegant looks, the sophisticated looks, the way we see. And now most of the phones, even the ones which we are using, you are using, they look very similar, or most of them, they have the same pattern. Of course, maybe technology-wise, Apple is much advanced, but otherwise looks and other things, they are quite close to Apple's. So that was at the heart of the fight or the dispute. And utility patents were like bounce back patent, scrolling and tap to zoom. All these, anyone who has been using smartphone, we all are familiar with them. Maybe the numbers and other things, that's another thing, but otherwise feature and utility and in practical sense, we all are familiar with it. Lokesh, if you can move on to the next slide, please. Yes. So these are the pictures. Most of the pictures are the ones which Apple had submitted against Samsung as evidence. These are the patent. These are the design infringed by Samsung as put across by Apple in the court. So these are about the looks of it, how these icons are arranged on the screen, on the display, and the boundary which they talk about. Then the as you can see in the slide, the bottom row, the colorful icons, the way they have been arranged, all these things were there. Next slide, please. That also is a picture. Next slide is also a picture where we are comparing the two phones. Lokesh, yeah, this one. So here we see the two phones and the similarity or the overwhelming similarity, and which in their jargon they call deceptive similar, is very obvious. So these were the pictures which were submitted to the court by Apple to strengthen its point of infringement against Samsung. Next, please. Next is Samsung's allegation. Yes.
Should I take over?
One before it. Yes, this one. So every time Apple, as I mentioned before, every time Apple went to the court and accused Samsung of infringing, Samsung would again retaliate and allege Apple also of stealing one or two of its patents. And these were the few which Apple was accused of taking from Samsung or infringing from Samsung. So now there are a number of lawsuits against them, around 50 countries. This is July 2012, and they started in April 2011. So by now they were in, the dispute was spilled over to 50 countries, and it was around 19 or 20 law cases going on, or even more. And it was a mix of things. Somewhere Samsung was winning, somewhere Apple was winning. But luckily, all these other disputes, it went on for a year or two. But by August 2014, they decided they will put a stop to all the overseas lawsuits. Anything which was on outside US borders, they decided they will drop those lawsuits. And from here on, my friend Sokalingam will take over. Sokalingam, are you there?
Yes.
Hello. Yes.
Good morning, everyone. I'm Sokalingam, so I will be taking from here. Tampered images as evidence. Further, the Apple submitted evidence to the court, which included, as we can see, they provided two side-by-side images comparing their phone and Samsung phone. But later it was found that Samsung phone image was tampered. They have actually cropped the image to show that both aspect ratio was same, but actually it was not. It was not same actually. They have just tampered the image. Next slide, please. So the jury started in July 2012 in US. So both sides provided cases, that is evidences and testimonies. They also submitted a large amount of documents. Finally, in August 2012, the US court gave $1.05 billion, awarded $1.05 billion in favor of Apple. Apple had not infringed against any of Samsung standards. Essentially, I will explain. Hence, it was to receive nothing. That is, they didn't give anything to Samsung. Only it was totally in favor of Apple. Next.
Yeah, just 1 minute. Go back. This American jury. What do you mean by American jury?
It was a lower court, sir. Lower court in America.
Okay.
They actually, even instead of submitting so much of document, they just spent 21 hours. Actually, both the parties thought they will be asked, it will prolong, but they decided quickly in the 21 hours in favor of Apple.
Continue.
Next slide. So, it was it was criticized by for a lot of the deficiencies, the judgment. It raised fears and insecurities in the smartphone industry. They questioned the competency of the jury. Both parties expected the jury would take longer since they were given more than 700 questions by numerous technical experts, including highly technical documents. Next slide, please. So then again, series of retrials and repeals followed. In 2013, in a retrial, the penalty of $1.05 billion was reduced to $600 million. But also the jury added Samsung should pay Apple over $290 million for infringing the patents. In 2014, in one of his trials, a jury found both Apple and Samsung infringing upon each other's patents, for which Apple was awarded $120 million and Samsung only $160,000. So in 5th August 2014, an important development, the two decided to drop all overseas lawsuits. Next one, please. So in 2016, the Samsung reached Supreme Court, appealed in Supreme Court. In that, Samsung challenged the lower court verdict. Actually, the lower court has previously asked the Samsung to pay all 100% of the profit it earned by selling the products which are infringing the Apple's patent. So the Samsung appealed against this, and the Supreme Court rejected the ruling of the lower courts, and it returned the cases to the lower courts, since it is not right to give all 100% profit. So further, the Samsung sought to limit damage to about $28 million, saying it should pay only for profits attributable to the components of its phones that infringed Apple patents. Next slide, please. Next slide. So on October 22, 2017, a district court judge, he ordered a secondary trial based on the conditions and limitations imposed by the US Supreme Court. So eventually the jury trial damage concluded on May 24, 2018, awarding Apple only $539 million, which included $399 million for damage of Samsung products sold that infringed on the patent. So Samsung previously paid $399 million to compensate Apple for infringement of some of the patents. Next slide, please. So finally, in May 2018, the verdict reduced to $539 million for Apple, which includes $390 million, as said before. But later, the two could reach an agreement before it could be litigated again. So in 2018, 26 June, the two litigants notified a district court in Chantos that they were agreed to drop or settle their remaining claims and counterclaim in this matter. So the companies, so they went for out-of-court settlement, but they didn't disclose the amount they have got or settled publicly. So finally, the war came to end, and the judge signed the order dismissing all the suits, and which said they cannot further pursue it based on the same claim in any other court. So that was the final settlement. Now the next person will continue.
Yeah. So as far as you have seen that it's all about the design infringement. So what we see that what is design infringement test, right? So design infringement test is the first. Uh, it should be the ornamental features of the patented design should be unique and not in the prior art.
So you have taken long time, very long time, more than I think 15 minutes. Quickly,
Yeah.
wind up in 1 minute.
Yeah, it'll wind up in quickly. So, so the next test would be that the products that the features should be unique, and so if the features are unique, then there would be an hypothetical ordinary observer that's who will test the two products, and it should if they are deceptively similar to an ordinary observer, then it's infringement exists. Moving on to the next slide. Yeah, so as you see in this picture that the jury applied the design infringement test, and we can see that prior art Apple patents and the Samsung Galaxy Tab. And as you can see the first row, and in the next slide we can see that the jury's verdict was that in the first row the tab did not infringe the Apple's design. In the third row the Samsung Galaxy S4 chip infringed Apple's design, and in the fourth row, the Galaxy Infuse 4G did not infringe Apple's design. Yeah. Hello, basic.
So moving on to the next slide. So we can see that there is a lot of similarities between the Apple's model, and which is in the left, and Samsung model which is in the right. That is the notch on the, like the mic on the up side, and the button on the bottom side, and a lot of similarities in the icons. And also we can observe that before the launch of Samsung's Apple's iPhone, the Samsung phone were used to be like the most of them were keypad and thicker, and after the release of Apple's iPhone, the Samsung's design changed drastically, as we can see in this slide. And this is one of also one of the images which show lot of similarities between the Apple's and Samsung's phone. And these were the like on the left side, it is the Apple's design, and on the right side it is Samsung design. So we can see that there is not so much difference in the design that and also moving on to the next part, Apple also submitted this image in the support of iPad's unique look. uh, and moving on to the next part, like in one of the interesting outcomes, UK's court ordered the Apple to run ads in newspapers and publish on its website that it hasn't infringed the Samsung hasn't infringed any of the Apple's design patent on the iPad, and it was to stay on their website for 6 months. And moving on to the next part, the verdict. Abhishek will continue.
Yeah, the final verdict was that in the decision, the jury said Samsung primarily infringed on two Apple's five patents. So the 647 and 721 patent covering the features that turned addresses and phone numbers into links, and Apple's site to unlock patent respectively. And we can also say that the jury also said that three models of the iPhone and two models of iPad Touch infringed on a Samsung patent covering a photo and video gallery feature. Also, not all Samsung products infringed Apple's patents, but as accused of Samsung devices, those were found to infringe the patents. In the next slide, yeah. So in Samsung defense, Samsung questioned the validity of Apple's utility patents. So in its support, they showed that uh, it showed of two computer systems that had similar functionality and predated the iPad and iPhone. So it was developed in 2001 by the MERL, and it was the Diamond Touch feature. In the next slide, we can see that. So in the Diamond Touch feature is actually it is a multi-touch and interactive PC interface. So where human interface device has the capability of allowing multiple people to interact simultaneously while identifying which person. Uh, so in the next part we have the in Samsung Paperwork.
Okay, you are taking too much of time. You have to close it in next half minute now. Okay.
Yeah. Okay. In Samsung defense, yeah, Samsung Paper sought to undermine Apple's accusations by showing it already working on rounded rectangular handsets, and also it also claimed that Apple's ideas were not original. It were heavily influenced by the Sony, and it showed pictures in the next slide. We can see that. Yeah, so this is the picture of Sony, and they also said that anti-utility patent involving bounce back feature was defended with the app launch title. This is also supported with a picture shown in the next slide. Yeah, so this is the launch title which manages 36 applications arranged in a 3x3 grid, and there are three pure zoom levels provide tired access to application details. And in the next slide we can see that the conclusions and key takeaways.
So in the conclusion, we can see that the design pattern wars are a message to the companies which can seriously impact the corporates, and like the case undermines the importance of filing more and more design patents to protect the look and appearance of new product brought in the market, and it brings out the importance of conducting an extensive patent search before launching the new product. And it can potentially harm the industry also if it is not sorted properly. And lastly, we can say that unbelievable amount of damages like the one in the favor of Apple can bankrupt the opposing company also. So the company must review their intellectual property to be safe, and IPR law experts should be consulted before this. And the company should consider how close is too close, that is the designs, and the unclear boundary of design infringement needs questions and cautious handling. So we this concludes our presentation.
Thank you. A good presentation. And now you can see all people who are present in the class right now can see that how important is the IP policy of a company, because this runs into millions and billions of dollars, and hundreds of millions or billions of dollars. So all MNCs, they are very careful about it, and there are several hundred people working in the IP department of such MNCs. And all of you have done this course, and the purpose of this time giving this infringement cases to each group. And if you are, if a person is listening to all the presentations, I'm sure that you will be much more knowledgeable and have a good feel of it. Okay, and you'll be able to make good career in IP departments of these companies, which are very paying jobs. Okay, thank you very much. Well done.
Thank you, sir.
Thank you, sir.
In your presentation, you had shown the references also, if I understand correctly. Yes or no?
Yes, they are there in the next slide after thank
हाँ
you.
तो वो भी तो दिखाना होता है ना, because previous presentation में उन्होंने last पर वो नहीं दिखाया था इसको, वो last जो है, because everybody is expected to have the references. So conclusion, references, then thank you slide. Okay.
This is the
because everybody should show up to the last slide and then thank you slide. Okay. Thank you. Which is the next one?
Excuse me, sir, can we present group number 14?
Yes, sure.
Rishan, keep, you have to do the job of timekeeper. After 8 minutes, you have to tell ki 2 minutes are left, and after 10 minutes, you have to say that wind up in next 2 minutes.
Okay.
Sir, is my screen visible?
Yes.
Yes, so should we start? So good morning all. We are group 14 and today we will be going to cover an interesting case which has been going on from decade ago, which is the Basmati war between the India and Pakistan. So next slide please.
Camera of fourth participant is not on.
It's there, Ashwini. Yes, sir. Intro. So the Basmati case against the rice tag was an eye-opening case for an India in the sense that it brought the spotlight an instance of gross exploitation of the intellectual rights and how ill-prepared the India was. In this presentation, we will explore the several claims made for the Basmati GI tax by India and Pakistan in the European Union following the rice tax issues. Rice tax was an American company. A report on what updates have been made to the case and the claim by the parties involved and as well as the possible steps for the future resolution. Next slide, please. So before moving into the case first, let's have an overview of the product, which is Basmati. Next slide. So Basmati historically grown in specific areas of Himalayan foothills of Indian subcontinent, such as the Himachal Pradesh, Punjab, and etc. We will look into the details of this part in coming slides. It is characterized by the extra long slender rice grains that get elongated almost 2 times the original size after cooking, while also having a soft and fluffy texture. And in India, there are around 34 varieties of basmati rice that have been notified under the Seed Act 1966. So due to its the vast history and the large area covering basmati agriculture, India is the leading exporter of the basmati rice to the global market. Next slide, please. So here we can see that India has been
just in the previous slide. What is the meaning of it is terribly hot? What was that?
Where?
Previous slide. Third point.
Where?
Say.
No, sir. Actually, sir, it got misprinted up till the 1960s. Sorry, sir.
What is last this? Notified under the Seeds Act 1966.
Yes, the point is up to 19. The last line got misprinted.
From the sun, it is terribly hot. क्या है ये? What is this?
It is. I think it got misprinted.
हाँ तो ये थोड़ा चेक करना चाहिए ना पहले प्रेजेंटेशन से. चलो आगे चलो.
Sorry, sir. So here we can see that India has been the leading exporter of the rice, followed by the Vietnam and the Thailand, and then the Pakistan.
अच्छा कंट्री वाइज का W छोटा होना चाहिए भाई. It is one word with hyphen. So जो second part होता है ना, that should be a small letter.
Okay, sir. Next slide. So the Ashwini will continue.
Thank you, Asher. So, origin of basmati. Rice is an integral part of life in the southeast and other parts of Asia. Basmati rice has been one of the fastest growing export items from India in recent years. So, in India, historically, basmati rice has been cultivated in Indo-Gangetic plains at the foothills of the Himalayas. In modern India, this region is spread over Himachal Pradesh, Punjab, Haryana, Uttarakhand, UP, Delhi, and Jammu and Kashmir. In the state of in the state of Uttar Pradesh, basmati is grown in the many districts like Meerut, Bulandshahr, Gautam Budh Nagar, Ghaziabad, Muzaffarnagar, and etc. In Jammu and Kashmir, Jammu, Kathua, and Samba grows basmati. Next slide. In Pakistan, the Kalar Belt, a piece of territory between the Ravi and Chenab River, which includes Saikot, Gujranwala, Hafizabad, and Sheikhpura in the Punjab province, appears to have a basmati belt as well. Next, sure, we'll go through this.
Next up, we have the case history, the what have been the previous actions in relation to the basmati. So, the international market of basmati has been an eye-catching for everyone. So, an American-based company called as Rice Tech, they crossbreed their native produce to produce a product similar to basmati, and they claim their rights and got a patent on it in their national. Now, what happens that this triggers to Indians that since this basmati has its own uniqueness due to the region in which it is grown, also has huge consumptions in India, has social and cultural linkages to the Indians, then how come an outside body claim legal right over it? So, and also back in 1999, when this was filed, India had not that robust IP infringement laws, and that's why means India was losing ground. But based on some scientific evidences that how Indo-Gangetic plains impact the characteristics of the rice, what importance does this land has, and it cannot be faded away by the lab-produced rice. And thus, based on these arguments, Basmati was granted the GI status, and Rice Tech was forbidden from selling rice under the tag of Basmati. The next case history comes to the MP government. So MP government was trying to get was trying to get patent of their rice produce under the tag Basmati. So they took these issues even to the Honorable Supreme Court of India as well. But this was seriously opposed by AIREA, the All India Rice Exporter Association, as they said that since Basmati has the GI status and Madhya Pradesh do not come under the geographical region, that is why we cannot allow them to have the rights of we cannot allow them to have the patent rights. And also it also impacts on the grounds on which India won against Rice Tech. Means we should always have the integrity of the reasons on which we have won the previous allegations. So that cannot be defied. That's why we cannot allow the MP government to have the right of Basmati. Next up, we will be building up this case. So as Pakistan takes this case to the European Union, we have Pakistan as the plaintiff to the case and India as the defendant to the case. And the case will be analyzed based on the how does this GI status impact their individual rice markets. Also, what arguments India gave to the gave against Pakistan on international platform, and also what can be the possible solution to this issue. We'll be discussing based on that. Next up, I would like Ashwini to discuss on GI status and rice market.
Jaykant.
Yes, sir.
So you have been saying the patent on basmati. 3 times you said patent on basmati. Is it patent or you're talking about GI?
It's a GI status of basmati.
But 3 times you spoke patent on basmati.
I am sorry, sir.
Achha, second thing, you all 4 people should know the basics of the term paper. You said 34 varieties of basmati. So
Yes, sir.
all the 34 varieties of basmati are being grown in the Himalayan foothills, or it is some other places also?
So some other places as well.
Say like Madhya Pradesh. Yes or no?
Yes, sir. Means actually in the case of Madhya Pradesh, they also produce, means they claimed that their variety of basmati should be given the rights, the GI status.
चलो ये क्लैरिटी नहीं है, आगे चलो एंड टाइम का ख्याल रखो अपना.
So GI status and rights market. So as a prerequisite, European regulations required third-party countries to have their own GI laws in place that protect the product. So Pakistan got its domestic laws passed in March 2020, whereas India passed its law in 1999. India also has a domestic GI tag for basmati, and Pakistan also got it recently. According to estimate, GI tag for Indian basmati could have increased the country's export to European market from 250 to 500 million US dollar. According to figures from the Union Commerce Ministry and the All India Rice Exportees Association, India shipped $245 million worth of basmati rice to the Europe in 2021 compared to $207 in 2019-20 financial year. In terms of volume, it was 2.88 lakh ton, up from 2.11 lakh tons this year. Similarly, Pakistan export 2 to 2.5 lakh ton of basmati rice to the European markets. India exported 4.4 million tons of basmati rice in 2019, with only 2% of that going to European market. Pakistan's export volume in 2019 was 846.8 thousand tons, which is significantly lower than that of global average. However, Pakistan is relatively more dependent on the European market, with 14.8% of its basmati rice going to European countries.
Where are these figures you are speaking? They are not being shown here.
Sir,
So we have given these all these figures in the report.
Right from जयकांत जो भी जो बोल रहे हो वो कहीं स्क्रिप्ट लिखा हुआ है वो बोल रहे हो, दिखा कुछ और रहे हो.
Sir, we have mentioned everything in the report, sir.
अच्छा, report separate है.
Yes, sir. Report is separate. This is just the presentation. Means we have taken. Yes.
ठीक. Okay.
So the fall of India's export of basmati rice to the European, the reason for this is the pesticide which is banned by the European countries and is used by Indian rice growers. This has put Pakistani exporter at a temporary advantage. And Europeans' total import of rice during September to May in the previous slide were 0.9 million tons, out of which India contributed 16.4%. The reason for the fall in exports during April-May has been a slowdown in demand amid the coronavirus pandemic. Furthermore, some of these countries are tightening their pesticide norms on basmati rice, and the GI mark allows consumers to trust the original product and its promise of quality. So the tag offers protection and also it's a lot of brand equity and monetary benefits.
अश्विनी, तुमने कुछ भी नहीं किया क्या टर्म पेपर में, या बाकी तीनों ने किया सारा काम? कुछ किया है या नहीं किया है? इतना धीरे धीरे अटक अटक कैसे पढ़ रहे हो, जैसे कि पहली बार लेटिन फ्रेंच ग्रीक पढ़ रहे हो? हाँ, वाई सो? चलो जल्दी जल्दी जल्दी, ऐसा धीरे धीरे मत पढ़ो, जल्दी जल्दी बताओ, चीज़ें आनी चाहिए, यू शुड बी वेरी, और जितना काम किया है नहीं किया है, यू शुड हैव डन एडिक्वेट रिहर्सल बिफोर हैंड। ये नहीं कि बस मेरे को बता दो कि क्या पढ़ना है, ठीक है। मोदी जी और वो है ना जो दूसरे उनके अपोजिशन के लीडर्स हैं, मोदी जी एक्सटेम्पर बोलते हैं, दूसरे जो हैं वो कागज देख के पूरा उसको पढ़ते हैं, देखा है ना, इफेक्टिवनेस किसकी ज़्यादा होती है। चलो जल्दी से करो, जल्दी जल्दी करो।
That's it.
हाँ
Next.
So we move on to India's application to the European Commission. So next slide. So India applied for the PGI status or the protected geographical indication status for basmati before the European Union around July of 2018, and the application was then published in their official journal around September of 2020. Now, in the application, India stated that basmati is being produced in particular geographical regions of the Indian subcontinent, and they specified the regions. They did not claim that they were the only country that grows basmati. However, if they were still to be granted GI status in their favor by the European Union, then, like we said before, the perceived value of the product from Pakistan might change. So, in around December of 2019, the Indian claim to the European Union was contested by Pakistan, and the main basis or the point of their opposition was that Basmati rice was a joint product of India and Pakistan, and the historic origin could be tracked back in time. And following this, India and Pakistan also had a couple of months, I believe 6 months to be exact, in order to resolve this issue between themselves, but it didn't prove to be feasible. So New Delhi requested an extension, and it was set to expire September of this year. Next slide. So there was when it came to filing an opposition in terms of Pakistan, they ran into they might have potentially ran into practical problems, which were next slide, please. So as we mentioned before, Pakistan also enacted its own GI statute, which was a GI Registration and Protection Act around 2020. And a domestic GI registration, even though not specifically required, it could potentially strengthen their claim over the Basmati GI. So, but in order to grant a GI, a challenge that they might have faced was the fact that they are required to give proper demarcation of the area. Improper demarcation might potentially weaken their claim, like in the case of the Madhya Pradesh government in India also, even though that was domestic. Next slide. So the possible grounds of opposition that could be covered by Pakistan are filed under Article 10 of the regulations, which was published by the European Commission. Next slide. So Article 10(1)(a) showed that it dealt with the basic eligibility requirements and product specification requirements, and in this regard, India met all the fundamental requirements, so this could not be a possible ground of opposition. And Article 1B mentioned the examination of whether the proposed name was incompatible with the name of any other plant types or animal breeds or homonyms and trademarks. In this regard also, Basmati did not clash with any of the names of any above mentioned group, and so the basis cannot be used. The third claim, however, was based on Article 10(1)(c), and this was a substantially credible claim. It required that it talked about how the opposing party can demonstrate the existence of a product that had been legally in the market 5 years prior to the date of publication, and the fact that this could be jeopardized by the registration. Now, according to a 2004 European Council decision, there was agreement between Pakistan and the European Union where duty-free imports of certain varieties of basmatis were allowed into the European Union. So that was substantial basis. Another thing was that in the rice tech incident mentioned above, India had actually recognized that Pakistan also grew basmati rice in their region as well. So these were good claims that could support Pakistan. Article 10(1)(d, on the other hand, dealt with the provision of evidence on the basis of which it could be concluded that basmati is a generic term. But it can be a weak argument if you look at the fact that India is also relentlessly pursuing against attempted registration worldwide and is trying to prevent dilution of basmati GIs. Next slide.
Next up, we have that how this two-party dispute is taking a shape of a tri-party dispute. Nepal is also trying to get the GI status of basmati. So Nepal also wants their produce of rice to be allowed for sale in the international market. They give the following arguments. See, they have a history of basmati similar to what India has been having. Next up, we have the R&D. Nepal has been investing a lot of money on R&D to produce different varieties of basmati. So they want that they want the benefits of their invested amount. Next up, we have the cultural association, similar to the cultural and social linking that India showed in the rice tech winning. Nepal also has similar association to the basmati. However, the argument of Nepal weakens because they do not have the national national laws which protects its GI status, and also similar to the status that India had in 1999, the Nepal are also in the similar stage. Next up, we would like to conclude this. So as per the Article 13 of the regulations at the European Union, it states that a PGI shall not become generic and even protects the use of basmati with words such as style, type, method, as produced in, imitation, or similar. Next up, we have the case failure. In case Pakistan's opposition fails, India will have a lot of gain as the sole GI holder for basmati in the EU, and then they can make heavy transactions in terms of exporting basmati. Next up, we have the possible solution. The possible solution can be that we can come into a practical and mutual beneficial approach for both the parties. They can come into compromise, and this can benefit both the parties. This ends our presentation. Thank you very much. And here are the references to the references that we have used.
Thank you. Good presentation on basmati, but my suggestion is that you should be more familiar with the whole thing rather than reading it out from your written term paper. Okay.
So sir, we did try to put up only the materials that means so that we can show it here and then we can
नहीं, that is true. But जो देखिए show करते हो ना, after that you should be able to make what I say. You should be able to explain everything from there. You should not be having another script to read. You're getting my point?
Yes.
You should not be reading from another script, right? Chalo, good. Next.
Thank you, sir.
Number 9.
Okay.
Good morning, sir.
Good morning.
Sir, all the members of my group are actually not present because they have some placement activities and a quiz. So is it okay that only one member presents?
नहीं. वो नहीं, कोई दूसरा ग्रुप करेगा प्रेजेंट. अभी तो वी आर ऑलरेडी रनिंग लेट, तो काफी ग्रुप पेंडिंग होंगे, अभी वेट कर रहे होंगे. बताओ कौन है इसमें रेडी?
Group number 10.
Group number 10. Yes. Serial number 8. Yes.
Excuse me, sir. We are group number 9 and we are ready.
अब 10 ने बोल दिया, पहले बोलते हैं ना 9. फर्स्ट कम फर्स्ट सर्व. तभी 10 के बाद में 9 कर देना, कोई बात नहीं है. ठीक है.
Actually, sir, Zishan sir just told us कि like 14 के बाद हमारा है.
तो पहले बोलना था ना. कौन रेडी है बताओ, 10 या 9 बोलो.
हम सब
do one thing, let group 9 present first, then we
डॉक्टर अभी ईशान ने बोला है ना 9 करेगा तो 9 करो पहले. चलो फटाफट करो 9 वाले. इशिका, अनवित.
Yes, sir. So Good morning, everyone. I'm Anvit, and today we are going to talk about a very famous dispute between two well known companies, which are Apple and Microsoft. So basically, Apple alleged that Microsoft were using its graphical user interface without permission and sued them for copyright infringement in the year 1988. According to Apple, the primary aspects like presence of windows on the screen, their rectangular appearance, the resizing feature, etc., were the features that made them similar to Apple's Lisa and Macintosh operating system. So now let's get into some background details. Xerox was a corporation that developed a graphical user interface in 1970 and demonstrated it to Apple representatives in the year 1979. At that time, Apple was developing processing chips and user friendly interfaces for its Lisa and Macintosh operating system. But later, in 1983, it released its first commercial computer with GUI extending Xerox work. When Microsoft released its Windows 1.0 in 1985, both companies had a dispute about licensing of Apple's GUI features. Bill Gates, who was interested in the interface and requested a software licensing, but Jean Gasse, who controls both the Macintosh and the Lisa, rejected the offer, claiming that their GUI were far superior and they will make a huge profit across it. But the sales of Macs were not as expected as they had predicted. So both parties agreed to a secret licensing agreement in which Microsoft was given to use its features for its Windows in exchange of Apple receiving some of its Microsoft's product. And further, Microsoft agreed to develop software for Macintosh and also with the purchasing of 150 million of Apple stock. And Apple agreed to make Internet Explorer as its default browser. So now I will let my friend Saurav to further elaborate and discuss on this topic.
Thank you, Anvit. So now, after the initial agreement between Microsoft and Apple in 1985, Microsoft released Windows 1.0, the first version of Windows, which had users which had features which enabled the users to zoom in on a window, minimize other apps which were still ran in the background and could be opened from the bottom of the screen. When Gosse saw this, he wasn't threatened by it at all. He didn't see it as a threat, but Scully, who was Apple's CEO, was infuriated by it. He thought that Microsoft used the prototypes and the source code given to them for word and multi-plan optimization were used by them to create an interface which was very similar to Apple. This infuriated him. Functions like write and paint were very identical to the Mac write and Mac paint which the Macintosh system offered. These similarities infuriated Scully because he thought that a company with only $25 million in sales, that was Microsoft, was trying to rip a company which had more than $1 billion in revenue. So he was very unhappy about it. So he sent John Brown, one of the best legal attorneys, to threaten Bill Gates for copyright violating the Apple's copyright. So now the legal battle followed. So midway through the legal battle, Xerox, which was another corporation, filed a countersuit against Apple and claiming that they too infringe upon their copyright. But Xerox had licensed various GUI features to Microsoft too. Also, Apple had also purchased GUI parts from Xerox for $100 million. So while the case was going on, Bill Gates was preparing for the launch of the Microsoft IPO, and John Scully was trying to popularize Macintosh, whose sales were dropping. So they both wanted to avoid a long legal battle. So they signed a cross agreement on November 22, 1985, in which Apple agreed to license Macintosh visual displays to Microsoft for using software derived from Windows 1. And Microsoft agreed to continue developing its Mac products for the Apple products. For and also agreed that it will only release its feature enriched Excel only for the Mac products for 2 years. And this deal proved very profitable for Apple, whose profits nearly doubled by 1987. So this was very fruitful for them. So now we come to a few years later in 1987 when Microsoft released their further version of Windows, which was Windows 2.0. After seeing Windows 2.1, 2.0, Scully realized that it was a very big improvement on Windows 1.1 with fantastic features such as Windows on screen, rectangular appearances on Windows, resizing features, etc. And also it had custom made programs for Windows 2.0. Sorry. Microsoft announced during the press conference that it had completely developed the Microsoft Word and Microsoft Excel for Windows, and that independent businesses such as Aldus, Corel were working very hard to create Windows 2.0 compatible software too. This he saw, John Scully, this he saw as a big threat to Apple's market share, because he thought that all the products that Apple had would be overshadowed by this feature enriched Windows 2.1. And so he thought that this infringed on Apple's copyright, because the initial agreement which they had only covered Windows 1.0 and not further versions of it. So they continued on their legal battle. Now I'll pass on to Nishant, who will explain the copyright laws related to it.
Good morning, everyone. So, like Apple filed a lawsuit against Microsoft that the Microsoft Windows Apple's Macintosh GUI. Apple prepared a list of 189 characters on which they claimed that there was intellectual property infringement. Also, according to copyright law, like if the plaintiff is arguing for total protection of total concept and feel, but the discrete elements that make the whole are not individual copyrighted. Means like in case of GUI or Windows, the individual features like the rectangle we were talking about earlier or the toolbar, they are not if they are not individually if they are not individually copyrightable, so uh, they cannot claim copyright unless the virtual copy is exactly the same. So the main objective of the copyright law is to promote the progress of science and useful art, and at the same time to award the authors and inventors for their discovery, and to provide them with the exclusive rights. This helps the public and also motivates the individual to work and also helps them with monetary benefits. Uh, like the code of a working software comes under the definition of copyright laws, but the appearance and feel it's not like it's debatable should appearance and feel come under this under copyright laws. It varies from case to case.
You have 4 minutes left.
Yeah, sure. And so, like the government enacted IP protection regulations so that it can promote the competitive spirit of business and also prohibit other individuals or enterprises from stealing each other's ideas. Apple filed the copyright lawsuit based on these outlines. Now I would invite Ishika to elaborate further on the court rulings.
The final court decision was based upon the 1976 Copyright Act and the limitation and extents of the intellectual property rights. The court stated that even similarity in expression is non-infringing when the nature of the creation makes similarity necessary. What it meant to say is when I supposedly if I have to develop a windowing system and I have to show various tabs simultaneously, I have only two options. Either I could tile them or overlap them. Considering the point that users usually prefer the overlapping feature, it would be unfair to grant protection on these resulting expression as it would be like conferring a monopoly on the idea. Also, the copyright law extended only to the expression of ideas and not to the idea itself, which the court stated. Moreover, we all know that the use of visual displays and photographs adds to the appearance and makes the interface very appealing. So considering all these facts and that the icons, symbols and functional components are not specifically unique, so they all should not be protected under the Copyright Act. So, considering all these limitations of the computer environment, the court concluded that it could not be protected under the Copyright Act. These are some of the news clippings which were from when the case was going on. So, finally, it was concluded that Microsoft didn't breach Apple's copyright in the Macintosh screen displays. A major flaw in the case was that Apple didn't build its interface from scratch. Moreover, it actually took license from Xerox, who had the original ideas. Moreover, the 189 aspects which Apple claimed that Microsoft plagiarized from their interface, out of them, 179 were actually already covered under the agreement which Apple has granted them when on the launch of Windows 1.0, which stated about more than 90% of the aspects. So, on 19 September 1994, the Federal District Court stated that Microsoft did not breach Apple's copyrights, and Microsoft won the case by a vote of 3-0. These are some of the references we used, and thank you.
Good. Thank you.
Thank you, sir.
Thank you. Good.
Group number 10.
Hello.
Group number 10 can start the presentation.
So actually, one of my team member is so busy right now, and he's saying that he won't be able to join before 11. Would it be possible if we could shift our presentation after 11?
Okay. So who is ready right now?
Okay, sir. Thank you.
Group number 12.
Yes, sir, we are.
Yes, sir, we are. Is the screen visible?
Yeah, it is.
Yes.
So, hello everyone. I'm Sagar with my teammates Akshat, Harshika, and Sanskriti. We are discussing the IP infringement case of Oracle and Google, which are the two major software giants in the
Camera
current
of
sector.
fourth participant is not on.
Sorry, sir.
Uh, Only three members. Okay, I got it.
Okay, so can we continue?
Yeah, sure.
Thank you. So, uh, since our topic is our cases of two software giants, Oracle and Google, our presentation will be quite technical. So please bear with us. मतलब थोड़ा technical का we are trying कि ज़्यादा technical ना हो. So what is Java? Java is an object-oriented programming language where the programmers can write their source code on a platform independent object code, which is bytecode, which can be run on any OS, which is Windows, iOS, and Linux. And then we want to clear a software term which is application programming interface (API), जहाँ पे बहुत सारे पैकेजेस बिल्ड रहते हैं ताकि जो बाकी प्रोग्रामर्स हो वो उन्हें उन पैकेजेस को यूज कर सके एंड दे कैन डेवलप सर actually there's a noise from someone's mic. Thank you. So API comprises of many packages which can be used by many developers to make their products easily. To clear out what API is, I want to give an example of recent COVID era. We all have heard the example of COVID portal. So COVID portal का जो API है, which is highly appreciated in the world, and our PM Modi decided to make the COVID portal's API open source so that any other country can use it for their COVID management. So Java's API comprises of a library of pre-written programs that can perform tasks and functions, and the developers who come on Java to build their product can use that Java's API and build their product efficiently. And in 1996, Java's API comprises of only 8 packages. But by the time Oracle acquired Sun Corporation, of which was Java's owner, Java's API number had 166 packages and with 600 classes and 6,000 methods. And these classes and methods are the terms which classes are the terms which are highly used in the object-oriented programming language. Classes are classes को हम लोग basically product से relate कर सकते हैं, and methods are basically functions to help build that product. And then we want to discuss Android. Android is basically जो हमारे मोबाइल फोन्स में ऑपरेटिंग सिस्टम होता है, तो which was built by which was and the current owner of Android is Google. जो Android का जो source code है, it comprises of 37 of the 166 Java's packages. These are the 37 Java, Android Android packages. We can see that there are these blue are written in Java, and these are Google's contribution to the Android architecture. And now, Sanskriti, you can continue with the presentation.
Yeah. So, good morning, everyone. So, I'll continue from here. So, the replicated elements chosen by Google. The names of packages, classes, methods, and arguments were generally identical. Structure of or arrangement of methods into classes and classes into packages. Functions implemented, including inputs and outputs. So, according to Google, like all these things were replicated from the Oracle part. Next slide. Replicated elements prescribed by Java language. Form of declaration statements for packages, classes, and methods, and call to methods. Throw statements for generating exceptions. Standard terms, example, public, private, static. Types of values, for example, int, boolean, char, and string. Next slide. Next slide, Sagar. Previous one. Yeah, so the dissimilarities, the body of methods, the implementation, the lines of program of the instructions that implement the actual functionality of the method. So the implementation of the methods were not at all similar as compared to that of Google, as compared to that of Oracle. The net result, 3% of the lines in the 37 packages of the Android API were identical to Java API, and 97% lines were dissimilar. The timeline of preceding lawsuit. In 1996, Java released by Sun Microsystems. In 2005, Google acquires Android, begins negotiation with Sun to license Java. In 2007, Google releases Android. In 2010, in early 2010, Oracle acquires Sun. In late 2010, Oracle sues Google in NDCAF for patent and copyright infringement. Next slide. So, Oracle's position. Allowing copying for specification of the Java API leads to fragmentation and or balkanization of the platforms. API specification protectable under SSO theory and as a taxonomy. Structure of packages, classes, methods were creative and expressive. Organization of methods into classes and packages like a taxonomy. So, Google's position. Programmed its own implementation of an API and virtual machine. Any copying was privileged, fair use or minimum. Copied elements of Java API constitute an unprotectable method of operation. Harshika will continue from here.
Thank you, Sanskriti. Hello, I am Harshika. I will tell about the jury trials and the laws. So, in the jury trials, phase one was the copyright infringement, copyrightability assumed. Jury finds that the Android API infringed copyright in Java API and rejects defenses of the de minimis copying and fair use. Phase two was no patent infringement. Judge Elsop rules on the protectability of the replicated elements after the trial. Sagar? Main issue in May 31, 2012 order. While Google took care to provide the fresh line by line implementation, the 97%, it generally replicated the overall name organization and the functionality of 37 packages in the Java API, the 3%. The main issue addressed here is whether this violated the Copyright Act, and more fundamentally whether the replicated elements were copyrightable in the first place or not. This was said by Judge Elsa. Code distillation of the legal principles: idea, expressions, dichotomy, no idea, procedures, process, system, method of operation, concept, regardless of the form of, cannot be protected. Merger doctrine: when there is only one or just a few ways to express something, no one can claim their ownership of such expressions by the copyright. Names and short phrases doctrine: name and short phrases are not copyrightable in the Ninth Circuit. No sweat of the brow. Court should not yield to temptation to find the copyrightability merely to reward an investment in a body of intellectual property.
You have
Court
4 minutes left.
Yes, sir. Court criticizes the SSO theory, now disfavored in the Ninth and the other circuits, failed to recognize the danger of the conferring monopoly by copyright on what Congress had expressly warned should only be granted by the patent, effectively on assertion of exclusive rights to function, system, or method of operation belonging in the realm of patents. Next. Court chooses the abstraction filtration and the comparison analysis abstraction decides program according to its varying levels of generality to provide a framework. Filtration examines each level of generality or abstraction in order to filter out those elements of the program which are unprotectable. Comparison compare remaining protectable elements with the illegally infringing work to determine whether the defendants have misappropriated substantial elements of the plaintiff's work. Unpredictable element data filter: structure based on the practical considerations, structure dictated by the external factors, standard techniques, extrinsic considerations such as computer hardware, compatibility requirements with the other programs, demand of industry being surveys, widely accepted programming practices, hardware standards, software standards, mechanical specifications, structure already found in the public domain. Now Akshat will continue.
Yeah, thank you, Ashika. Good morning, everyone. So basically, the Oracle argued that packages, classes, and names that are copied are taxonomy, and taxonomies can be protected. But according to court, it is partially correct. The same taxonomy can be used freely to develop further programs. That means Java API can be used to develop further programs, such as development, further development in the Android and much more. This decision was taken by the software community in the early stage of the Android development. The Sagar, next slide, please.
2 minutes left.
Yeah. So basically, Oracle said that the Google copied the structure and sequences and organization of some Java APIs packages, but the structure, sequence, and organizations, which is SSO, is a legal term that is used in copyright trials. But technically, it is another way to say that the Google copied Java methods or functions and classes. No matter how you look at it, the claim remain absurd. The name of individual method, classes, packages are not protectable under the short names doctrine. The declaration of methods, classes, and their name can be copied in view to get interoperability in the software. In sum, Google and the public were like according to the code, the Google and public were remain free to use and create the replica of the Java API to further the development of the Android as well as their software, because it is an idea, not a particular thing which is developed by Oracle. The overall system of organization of methods are not protectable. Sagar, can you please move to the previous slide? Yeah. Arrangement and methods into classes and classes into packages involved creativity and resembles a taxonomy, but it is nevertheless a command structure, system, or method of operation. Google replicated, which was necessary, but not more than necessary to achieve interoperability, which is agreed by the code and cannot be alleged by the Oracle. Next slide, please. So, like basically giving my conclusion thoughts, Google beats Oracle in the biggest program copyright case ever. Oracle alleged Google the copying of the some Java Standard Edition APIs for its Android OS. Since then, the case has worked its way up and down the US legal system, creating two jury trials and numerical appeals. The court decision had reversed a jury finding that Google copyright copying Oracle software was a legitimate fair use. Oracle was demanding an insane amount of money, say $9 billion, which is about $1 million for each line copied, and they have created 11,375 lines approximately, which are similar to the Oracle code. Court was concerned with the extensive effects of the copyright law protecting elements of the software necessary to allow interoperability, and any kind of specifications of Java API is necessary to gain interoperability. Also, Google created Leprica with 3% similarity, which is no more than necessary percentage, and hence the court favored Google, declaring Java API can be used freely in the future for development of Android. Thank you. Here are some references which we have used, including Wikipedia, Google, and two other sites.
Thank you. Your conclusion should be more explicit. It is not in your slide. It is not coming out that explicit. Between the plaintiff and the defendant.
Okay, sir.
The final. Chalo. Okay. Thank you.
Okay. Thank you, sir.
Bye.
Group number 13. You are muted. Please switch on.
I will be sharing the PPT slide. Hello, is my screen visible?
Yes, it is visible, but it is not in full screen.
Yeah, so good morning all. I am Rishabh Kumar Rajak. I and my team are going to present the IPR dispute between Microsoft and Alcatel. Now, before diving straight into the IPR dispute, let's briefly go through the introduction of both the stakeholders. Now, first is Microsoft. So, Microsoft Corporation is an American multinational technology company headquartered in Redmond, Washington, that develops, manufactures, license supports, and sells computer software, consumer electronics, personal computers, and services. Microsoft was founded by Paul Allen and Bill Gates on April 4, 1975 to develop and sell basic interpreters for the LTI 8800. The company's 1986 initial public offering (IPO) and subsequent rise in its share price created three billionaires and an estimated 12,000 millionaires among Microsoft employees. In May 2011, Microsoft acquired Skype Technologies for 8.5 billion USD, and in December 2016 bought LinkedIn for 26.2 billion dollar. Uh, um, yeah. So Microsoft is market dominant in IBM PC compatible operating system market and the Office software suite market, although it has lost the majority of the overall operating system market to Android. Microsoft has an Indian origin CEO, Satya Nadella, similar to tech giants like Google. Microsoft has a market capitalization of 2.321 trillion USD as of October 2021. In terms of market valuation, this makes Microsoft the world's second most valuable corporation. Next slide. Yeah. So, Alcatel-Lucent SA was a French global telecommunication equipment company headquartered in Boulogne, Billancourt, France. The company focused on fixed, mobile, and converged networking hardware, IP technologies, softwares, and services with operation in more than 130 countries. It had been named industry group leader for technology, hardware, and equipment sector in the 2014 Dow Jones Sustainability Indices review. Next slide, please. Alcatel-Lucent also owned Bell Laboratories, one of the largest research and development facilities in the communications industries, whose employees have been awarded 8 Nobel Prize, and the company holds in excess of 29,000 patents. Alcatel was formed when Alcatel, a small company in Mulhouse, absorbed by CG in 1956, merged with Lucent Technologies on December 1, 2006. Nokia, a Finnish telecommunication company, intended to buy Alcatel-Lucent for 15.6 billion euros in all-stock deal on April 15, 2015, and gained full stakes on November 6, 2016. Next slide. Now let's get some surface knowledge of the IPR involved in the dispute. Lucent Technology merged with Alcatel in 2006, filed a lawsuit against Gateway and Dell in the United States District of the Southern District of California in 2003, kicking off the war between Microsoft and Lucent, and later Alcatel-Lucent. Microsoft voluntarily joined the lawsuit in April 2003, and Alcatel was added after it purchased Lucent. The first case is the MP3 and MPEG encoding and compression technology, whose patents were being infringed upon were used by Microsoft Windows Media Player in MS XP operating developed by Microsoft that were sold by Dell and gateways through their PCs. The second case was the product related to interactive video content programming. This patent was also infringed by Microsoft. The third was the one of the patent found to be infringed by Microsoft tablet PCs devices for motion on a tablet computer using stylus developed by GoCorp, which was brought by AT&T Laboratories, which later come under Alcatel-Lucent. Now, to get more insights into the case, Ritik could take over.
Thank you, Isha. Now we will see the patents which claim to have been infringed. The first patent is the perpetual coding of audio signals. So for low quality signals, this invention helps to reduce the bit size capability. Now, what is the bit size capability? As we can see that our hardware or latest computer hardwares work on zero binary signals 0 and 1, which we can understand like switches. So bit size is number of switches required for any computer process or function to uh, to implement. So the lesser the bit size, the faster the process will happen. So this patent was to help the low quality signals to reduce their bit size capability, and by masking the signals by adding geometrical interpolations. And this method was called variable radix packing. Due to this, its applications in reducing bit size occupied, this technology is very useful in sending signals and doing sound recordings and reproductions. So in the music industry, this patent played a very important role. And here we can see the information about the patent granted by the US, and the circuit which was used in the patent. So now this second patent case, which is the system and method for interactive video content programming. Now this patent was to help user to increase the video content sharing with the interface link, like pausing and unpausing the video and viewing the content linked to the interface link over the network. Uh, its application we can see in the MS Office files, where we can see that we have embedded videos in the files which can be viewed over the network, and similar application could be seen on e-commerce websites. Now in this picture we can see the algorithm which has been patented by in the US, and the patent which has been granted. This algorithm helped help the MS Office to establish this embedded video content programming, interactive video content programming through the interface link. Now the third patent, which is the touchscreen for entry system. Now this patent was to facilitate the display of specified form and to automatically display the predefined tools such as keyboard, menu, calculator, and other similar devices, and aid the user in entering the data in the specified fields. Now, this patent had its application like in the on the entrance doors, and we can also see such similar applications of this patent in our library. As we can see that there are different tablets where we input our data to find the books in the tablet. So this is the application, and this, in this slide, we can see that the patent which has been granted by the US, and the computer configuration which has been patented for such systems. Like we can see, different computers are connected to their respective touch screen and display panel, and there's a central computer which processes all the input data and output data of the touch screen. Now Abdul will continue. Abdul?
Abdul, you are muted.
Am I audible now?
Yeah.
Yeah. So I'm going to discuss about the damages involved in the third case. After the jury returned a verdict of $70 million, the district court or the local court addressed whether the amount should be reduced on post-trial motions. Now, before addressing that issue, the district court noted that this case illustrates the difficulty of properly valuing a small patented component without a standalone market within a larger program. Lucent's damage calculation was based on a lump sum license in the form of an upfront paid in full royalty. Now, the royalty calculation is particularly difficult in this case because the date picker feature is just one among many Outlook features, and Outlook, although sold separately, is much more commonly purchased as part of the suite of products found in Microsoft Office. Now, to overcome these difficulties, Lucent's expert attempted to determine the financial impact to Microsoft without the day patent technology in Outlook during the damages period. He included 109.3 million Office licenses along with 241,800 licenses of Outlook sold on a stand-alone basis. Now, he then multiplied that number. Here, I'm discussing how he calculated damages. He then multiplied that number by 3% to obtain the number of license sales Microsoft would have potentially lost without the date technology, which amounted to be nearly 3.3 million lost license sales. Now, the 3% figure was based on a survey conducted by a survey expert for the case, showing that 7% of Outlook purchase decision makers that used the drop-down calendar feature would not have bought Outlook if it lacked the drop-down calendar. The next step was to calculate a hypothetical revenue loss associated with selling 3.3 million fewer licenses of Outlook. Next slide, please.
You have 2 minutes left.
Yes, sir. Now, as a part of this step, the expert determined that Microsoft average per unit revenue $67 from sales of stand-alone Outlook, and he used the same number as a proxy for the value of Outlook sold as a part of Office. The local court also rejected Microsoft calculation of $13.45 as a reasonable base for Outlook because the Outlook would only account for 13.7% of the revenue for Office. Now, even though Outlook is the most popular Office component, the district court or the local court, however, accept an alternative approach suggested by Microsoft that $24.55 was an appropriate apportionment based on the four components of Office. Now, this approach allocated 25% of the Office revenue to Outlook. The district court found that this was the highest amount supported by evidence introduced at trial. Now, finally, the district court then followed Lucent's damage expert remaining methodology to determine the appropriate lump sum royalty, that was $26.3 million. Therefore, the court adjusted Lucent's damages calculation to apply only 24.55, not 67, to the 109.3 million Office license, and otherwise follows Lucent's damage calculation. The court concludes that $67 is the appropriate per unit revenue to use for 241,800 units of standalone Outlook that were included in Lucent's damage calculation. The court determines that a lump sum reasonable royalty of $26.3 million is the highest damages award that is supported by the substantial evidence, and that is award reflects the proper apportionment as required by law. Now the next learnings and trials will be discussed by Harsh. Thank you.
Am I audible?
Yeah.
Yeah, so dispute between Microsoft and Lucent began in 2003 when Lucent Technologies, which later merged with Alcatel, filed lawsuits against various companies, and Microsoft joined the lawsuit in April 2003. So the ruling agreed that the patents which were developed by Bell Labs before joining the Fraunhofer to create MP3 were infringed, and the patent values which were brought for $17 million from Fraunhofer were exceeding. So the trials continued, and on 2000 February 2007, the Alcatel Lucent was awarded $1.5 billion, which was claimed to be $4.5 billion, but that was way too much. And in August 2007, the Microsoft granted retrial because they thought that the insufficient evidence was provided, and the judge Rudy Brewster agreed to it, and the trials continued, and which on April 2008 the jury which allotted Alcatel Bright $367 million, which is in damages after finding that Microsoft had mishandled two rights which are with the UI in its item. Next slide please. And in June 2008, the interest to the amount $367 increased to $512 million, which after that the other infringements made by the Bright on the Microsoft were some of them were invalid, and the Microsoft ex-boss also didn't infringe on the Bright's patent. And in November 2000, Microsoft and Alcatel Lucent declared that they had settled all the cases between them. And in 2009, the higher courts above the region court accepted the trials by the local court, but they thought that the amount of $350 million is way too much. So they led to modern trials, which changed the damage amount of $70 million to $26.3 million. Now, next slide, please. Coming to the learnings which we had from studying this case, most of the patent infringement case which we had seen earlier in the documents are required for each and each company to be competitive in the industry. And by filing a patent, the patentees are restricting their competitors to make use of that specific technology. So in the first case, Microsoft argued that they had taken license from Fraunhofer. Instead, if they had taken license from the original patent holder Lucent Technologies, the jury wouldn't have awarded that much huge penalty as damages to them. And in third case, there is a lot of subjectivity involved in calculating the damages awarded to patentees. Microsoft was not satisfied with this calculation, so they challenged the jury's decision to arrive at the final figure, which led to the for a too much longer duration for this case, around 6 years. So these are the next slide. These are the references from where we had studied, and thank you.
Can you hear me?
Yes,
Yes,
sir.
sir, you are audible, sir.
Who is the defendant? Who is the plaintiff? किसने किसके ऊपर केस किया?
Sir, the patent fear of Alcatel, and the one who infringed was the Microsoft. So,
आपका
uh,
टाइटल पेज निकालो जरा सर अपना.
Yes, sir.
पेज 1 क्या लिखा है इसमें?
Microsoft Corporation versus Alcatel Lucent.
क्या होना चाहिए था?
Alcatel Lucent versus Microsoft.
तो टाइटल भी गलत लिख रहे हो, ऐसे क्यों हो रहा है?
Sorry, sir.
ठीक करो इसको, ठीक करके दोबारा भेजो.
Okay, sir.
Yes, sir.
चलो, thank you. Next. Who is the next group?
Group number 16, please start the presentation.
Hello, Zishan sir.
Yes.
Sir, can we do the presentation? It is group number 10. Actually, we delayed it. I was actually outside. I'm
Okay,
currently
okay, okay. You can
doing
start.
something.
Okay, start.
Uh,
Group number 10.
Abhishek, can you just send the screen?
Yes, sure. I'm just presenting the screen.
Sir, I won't be able to actually switch on my camera. I'm actually outside. Won't give me the latency to switch on the camera.
Okay. Okay, but where are other two members? I am
Yeah.
able to see.
Sir, aren't you able to see me?
Yeah, I am able to see the three members.
Yeah. Yeah.
Where is the fourth?
He's actually sick, so he won't be able to
Okay.
join.
Okay.
One second, I'll just start. So, good evening, everyone. Good morning, everyone. So, we'll be presenting on Microsoft Corporation versus AT&T Corporation, the term paper one presentation. Abhishek, can you move to the next slide? So, we'll start with what is IP infringement, a brief introduction about that. So,
Go to the next. Go to the next slide.
Abhishek, go to the next slide. We start with the introduction. So we have the United States patent law, which stops at U.S. border, with the exception of the extraterritorial provision, which is codified in the 35 U.S. Section 271F. It imposes liability on domestic suppliers who export domestically patented inventions for minor assembly in abroad in a manner that would encourage infringement if performed within the country. So in Microsoft versus AT&T case, the Supreme Court overruled a series of federal circuit decisions where they actually interpreted the meaning of this law uh, in a different manner, which was applied to a export of computer software. So we'll just start with the introduction of what was the law about, how it came to the existence, and then we'll move to this case actually, the Microsoft versus AT&T. So Abhishek, can you move to the next slide? Abhishek?
Can you see it now?
Can you move to the next slide?
Yeah. Yeah. Which slide are you seeing? Oh, yeah.
Third.
Yeah. Are you able to see it now?
So, yeah. Okay. So, yeah. So now the principle of territoriality. So, it's actually very the meaning of this is well identified from the name itself. The territorial principle is a principle of public international law which enables a sovereign state to exercise a jurisdiction over individuals within their state on legal person within their territory. So an alternative would be while we are studying the principle of territoriality is that an alternative would be for the foreign government for inducing foreign government to change their laws or actually increase enforcement efforts. The United States could enforce its laws abroad. An example would be the government could create domestic liability for the foreign infringement of US patents. So that would enforcement of such kind of laws abroad, like enforcement of laws abroad to domestic liability, is not widely practiced because of the major objection is the principle of territoriality. Can you move to the next slide? But US actually has this law, which is the this 271F. Can you move to the next slide?
Yes, I'm moving. One.
Okay.
Yeah. Can you see?
So yeah. So this is the case which actually led to the creation of this law, Deep South Packaging Corporation versus Latram Corporation. So so later on, the plaintiff in Deep South held U.S. patent for use to deshell and devein shrimp. Deep South Packaging Corporation infringed these patents by manufacturing the patented invention within the U.S. border. Later on, successfully sued for damages and obtained an injunction. However, later on, patent claimed combination of the combination of the machine, but not the individual component themselves. So Deep South actually skirt to the injunction. They actually started making the in the US and assembly outside. Then the later on again filed the case. It was won by Deep South by 5-4, where it was the case that making or selling an infringing machine required final assembly in the United States, and Deep South did not intend domestic assembly. Thus, Deep South did not infringe the Lightram's patent. So, moving on to the next part, we will see how Congress understood this case and how the law was applied. Abhishek will actually take over.
Yeah, so seeing so many inventions are taking place, and some companies are taking unfair advantage of like exporting the manufactured goods like developed by hard work and intellectual intelligent people of like US. Some people were taking advantage of that. So Congress took that in mind and enacted Article Section 271F in 1984. What the provision it had were basically two provisions. Basically, it like if someone has some patented component or patented process, so substantial component or substantial part of it cannot be exported from US, right? And second was like if there is some special component or like patented component, it cannot also be just exported and sold and without the permission and so on. So basically, clearly, one ambiguity one see here is what the component means here. So like how the ambiguity arises and how it builds on. I'll explain in the subsequent slides. And yeah, so one thing why it was like ambiguous was that this section 271F after its enactment was not in use after like 10 years or so in the next decade of its enactment, not much in use, right? People did not knew uh, what component means and what exactly it's interpret. So like it like Donald Shijin interpreted it like chemical parts are not uh, not do not come as a component under this, and you can export chemical components and then find out and then formulate your compound and sell it abroad. But later on, it was agreed that it also come under the component under this section 271F of the patent act, right? Now how the further expansion of this section took place, I'll go on this. It happened due to this case, Microsoft versus AT&T case. So what was the case about? Like it was the case about a speech program, a speech software. My AT&T had developed a program which compress and encode the speech for that, and Microsoft had incorporated this program in their one of the software called NetMeeting, right? So this was incorporated and it was included in their Windows version. So uh, once this having this background in mind, so what Microsoft did one smartness or cunningness, whatever we could say, that it shipped across abroad the master's version of Windows and uh, and just and just generated copies out of that, and then distributed it all over its customers abroad. But like clearly it shows that there is some infringement. The AT&T did not like this because it did not took permission from AT&T to do so. So it filed filed the case against it. So first in the district court. So what district court thought was like it is district court thought that component
under Section 271F also included the software. So it gave the verdict in the favor of AT&T and accused Microsoft of infringing the patent. Uh, and then Microsoft again went ahead and filed the case in the federal circuit. So federal circuit again took the same stand because it was of one of the earlier case, Eola's Technologies versus Microsoft Corporation, which made them to agree that this is a uh, this this is a software, and software invention also come under the patentability. So it is infringement. They gave this verdict. So after that uh, this went to Supreme Court, and the verdict eventually came in favor of uh, Microsoft. But let's see how it came in favor of Microsoft. So Mansi, over to you to explain.
Yes, thank you, Abhishek. Next slide, please.
4 minutes left.
Yes, sir. We will cover in 4 minutes. So the AT&T had two major issues. Their threshold issues was that whether for the purpose of Section 271F, software in the abstract is a component of a patent invention, and their secondary issue was whether Microsoft supplied components from the US. So AT&T majorly framed the case around a threshold issue. They stated that manufacturers embedded software into a patent invention, unlike a blueprint, according to the statutory wording, which does not contain a physicality requirement. Because Congress deliberately enacted Section 271F to extend the reach of US patent law, the presumption against extraterritoriality did not apply. The secondary issue was not used much for forming the case around because Microsoft had delivered golden master disks containing software to overseas manufacturer, which then made its duplicates and then practiced the innovation. So as a result, the secondary problem of Microsoft delivering components was immaterial. Abhishek, next slide, please. Yes. So Microsoft, being a major software, they restricted their arguments that it did not supply, it did not supply any to Section 271F components. So they recognized that when paired with a when paired with a computer to execute speech coding, physical medium storing object code was infringed on AT&T's patent. Yes, so Microsoft did not raise a defense based on claim construction. A victory on factual issues would have left unsettled the important legal question of whether software is a component under Section 271F, perhaps opening the door to similar claims in the future. Microsoft contended that its object code, as sent to overseas distributor on disk, could not be a component of a claimed invention under Section 271 of the Patent Act. Because the abstract object code lacked the tangibility, it could not be combined with anything to put the idea into a practice. This argument had several advantages. Did not require any pronouncement on the patentability of software. This was an issue which was avoided by Supreme Court consistently. Furthermore, the reason was not limited to AT&T's allegation. As a result, a positive decision would shield Microsoft from future liabilities for delivering object code to foreign manufacturers. Next slide, please. Yes. So now I would be discussing the Supreme Court's analysis. So Microsoft was found not to be infringing by the Supreme Court. The court only partially rejected Federal Circuit's decision by adopting Microsoft's restrictive reasoning and relying on the presumption against extraterritoriality. Instead of ruling on the matter, the court reasoned that abstract software could not be a component of a protected product for the purpose of Section 271F because intangible components cannot be combined with physical components. The distribution of a golden master disk containing code to a foreign original manufacturer under AT&T's patent does not result in Section 271F liability. However, supplying such a disk to a domestic producer may have resulted in a contributory infringement under Section 271F. Although the Supreme Court determined that extract code is a component of patentable invention under Section 271F, Microsoft may have triumphed on the basis that the component in the infringing device was not from the US, but was merely a copy created elsewhere. And this point of view was supported by various amicus. Next slide, please. From this case, we have analyzed that comity, practicality, and self-interest, these three supported the Supreme Court's use of the territoriality concept to resolving AT&T's case. In addition, the outcome yielded the correct economic result. Since its passage, international economic and legal chances have rendered Section 271F obsolete as a means of incentivizing innovation. The Supreme Court, on the other hand, did not limit Section 271F to the fullest extent permissible. The principle of territoriality dictates that the most restrictive extraterritorial interpolation to be applied to statutes. Instead, the Supreme Court adopted a narrower ruling limiting the reach of Section 271F by relying on the presumption against
This is what
extraterritoriality.
we are thinking. That is,
The court's use of the presumption contrasts markedly with the Federal Circuit's interpretation of Section 271F that are far more wide. As a result, this ruling should prevent any future desire of lower courts to expand their jurisdiction.
हाँ वो तो फिर ले आएंगे अच्छे से बच्चा.
Yes, thank you.
Where are your references? Mansi, where are the references before thank you?
We forgot to add that slide. We will add it again.
Where is your first? Bring it to the first slide. On the top. First slide. Make it the first slide.
Abhishek, can you move to first slide?
Term paper 1, Microsoft Corporation versus AT&T. Who is the plaintiff and who is the defendant?
Sir, yes, we did realize that this has to be reversed. Like AT&T had filed. So yes, it should be AT&T versus Microsoft.
One major mistake like the previous one.
Yes, sir. Yes, we did realize that.
You know, हम किसी से कम नहीं. आपने अपना ना तो फर्स्ट स्लाइड में नाम लिखा है चारों ने, ना लास्ट स्लाइड में लिखा है, कहीं कोई नाम नहीं है. ये पूरा टर्म पेपर किसी से बोरो किया है क्या? खुद लिखा है या बोरो किया है?
नो सर, हमने खुद ही करा है.
तो व्हेन यू हैव डन इट, तो इसमें आपका नाम तो आना चाहिए ना कहीं पर. नहीं आना चाहिए.
यस सर.
हाउ डू आई मेक आउट कि किसका टर्म पेपर है? किसको मार्क्स दें इसमें? किसी को नहीं देंगे. अपना नाम लिख के करेक्ट करके इसको भेजो.
यस सर, वी विल सेंड इट जस्ट आफ्टर दिस.
दोबारा भेजो करेक्ट करके और नाम लिख के. ठीक.
यस सर.
ओके. अच्छा, एंड आई सजेस्ट दैट ऑल ऑफ यू शुड राइट योर नेम. उसमें है ना नाम के साथ ईमेल आईडी भी लिखा करो. ठीक है.
ओके सर. यस.
सपोज दैट a leader says I want you to present this term paper in some particular program, तो मैं कांटेक्ट तो कर सकता हूँ ना.
ठीक है.
You have done so much of work. You are more knowledgeable on this than me. है ना? You have gone into the details. I have not gone into the details. Okay.
Yes sir, that's a very good point.
I can depend on your resources. तो सब लोग अपना ईमेल आईडी जो नॉट आईआईटी वाला बट जो जीमेल वाला टाइप का होगा वो सब लोग डालो अपना अपना. ठीक है.
Yes sir, definitely.
Okay, thank you.
Okay,
send it again after corrections.
Yes sir, we will send it again.
Okay. Take.
Group number 16. Group number 16.
Hello.
For group. You are from group number 16 or 17?
So from 16.
16. Let's start the presentation.
So actually, two are having you have message you, sir, and you have informed that the timings will be at 1 a.m. 1 p.m. Ours will be the last day. You have.
Okay. And group number 17?
Yes, sir.
Okay.
Hello. Yeah, sir. Should we start?
Yes, start, please.
Oh, wait a minute. Is my slide visible?
Yes, sir. It is.
Okay.
Yes,
So
it's visible. Please, all the member, please open your camera.
Right. So I'll start today. So good afternoon, everyone. Today we'll be talking about the case A&M Records versus A&M Records is a major music distribution company and which mushroomed during the revolution. So this is a single landmark case pertaining to intellectual property rights, and we'll be discussing the next slide. So some introduction about the case. A&M Records versus Napster was a milestone case, particularly pertaining to since there was a final ruling that the defendant Napster and this was one of the first cases in which such type of ruling was given, wherein the defendant was finally, uh, wherein the final ruling was given against the defendant itself. So the judgment passed by the United States Court of Appeal for Ninth Circuit was a very turning point in cases related to internet companies, since it addressed a particular application of copyright laws, and this was in the case of peer-to-peer file sharing. Sort of next slide. So some context about the case. The defendant Napster was one of the early internet companies, and it enabled peer-to-peer. So their network was capable of transmitting various file formats, but the popularity people was driven by its ability to share music files in the .mp3 format. So after this company was launched, there was a growing trend among music listeners wherein they could just go to their network and download free music from their network. So eventually there was a hit on album sales, which are distributed by major record companies. They noticed this trend that their top line and bottom line were hit by a large margin due to this particular trend. So naturally they intervened, and these companies finally decided to sue Napster for particularly direct contributory and vicarious infringement of copyright. And this was done in order to protect the intellectual property and further protect the revenues that were taking a hit because of free downloads from their network. The next slide.
Yeah. So now we will see in some detail about the defendant Napster. Right. So Napster was started in 1990 one of peer services. However, that were the highest available on their machine, creating a searchable list of music available across Napster's network. Napster's ease of use compared to other peer-to-peer made it a popular service for music. Instead of downloading song files for right, for users to access download complex files from other users. Next slide.
Past is going to be same and this is more geometry. So geometry is analysis. So there
Yeah.
is not like much
So now
calculating.
we will discuss about
It is
plaintiff
all
property.
incorrect. So
Like the case
cities
is
are
referred to as
because of
A&M
geometry
Records
works
versus
again.
Napster,
So
but
more
there is a
time
vast
to
list of
write.
plaintiffs, included a
lot
number
of written work is there, right? जब आप समझते
of
हैं तो
Universal
question जल्दी
Recording
समझ आ
Industry
जाता है लेकिन जब आप
Association of America, RIAA. Universal Music Group, Sony Music Entertainment (EMI), and Warner Music Group are known as the Big Four in the music industry. Of this list, only A&M, Geffen, Interscope, Sony, MCA, Atlantic Island, and Motown are listed as plaintiffs on the appeal. Right. So, and additionally, American songwriters and producers Jerry Leiber and Mike Stoller are included in the circuit court appeal. Right. Next slide. Yeah. So here is an overview of the whole case. RIAA, that is Recording Industry Association of America, alleges Napster for copyright infringement, right? In response of which the court orders Napster to stop the exchange of files immediately. Then in against, Napster appeals in United States Court of Appeals for the Ninth Circuit. And the court found that users are involved in the copyright infringement and then held Napster responsible for contributory and vicarious infringement. Right. The court ruled that file sharing by individual users was not fair. It was not a fair use, which would have exempted the activities from infringement liability. The court also ruled that Napster's role in facilitating the dissemination of recordings was not within the various safe harbors created by either the Audio Home Recording Act or the Digital Millennium Copyright Act. Right. Over to Saurav.
So let us discuss the issues which were discussed in the court. The first argument that Napster gave in its defense was the fair use argument. Fair use is a means of defense to infringement, which states that infringing activities are permitted if pursued for specific purposes. So the court analyzed the claim of Napster and analyzed it on the four factors. The first of them was purpose of use. The court ruled that the use of Napster's platform was not transformative. That is, the sound recordings which were distributed were the exact same copies of the original music. The court also reached an understanding that although Napster did not directly benefit from its users, it stood to financially benefit in the futures. Hence, it termed Napster's use as commercial use, even though there were no sales involved. Uh, The second factor was the nature of work. The court found that musical compositions and recordings were works of immense creativity. Hence, they must receive greater protection, due to which even this factor weighed against Napster. The third factor was amount of work copied. The court acknowledged that repeating copying could fall under fair use under the law. However, the court also reported that copying on Napster's platform was not only repeated but also exploitative. Hence, the court termed it as wholesale copying, and even this factor went against Napster. The last factor was effect on market. The court agreed that Napster's platform harmed the market of sale of CDs and discs for recording companies. An independent study by Recording Association was cited by this for the court. Napster also came with its own study, which proved that the sale of CDs actually increased using Napster's platform due to a wider reach of audience. However, the court discounted the Napster study. The Recording Association filed for different infringement for the Napster. The first of them was copyright infringement. Copyright infringement takes place when a person induces or instigates another person to materially contribute to copyright infringement. The court established that Napster had actual knowledge of infringing materials on its platform. Because the Napster did not do anything for this, hence the court concluded that Napster materially contributed to the infringement, which made it liable for contributory infringement. The next claim by Recording Association was vicarious infringement. Vicarious infringement takes place when a person is either directly or indirectly benefited and provides a platform for copyright infringement. For establishing a case of vicarious liability, the court analyzed 2 points. The first was the infringer had right and the ability to control infringement. On this point, the court noted that Napster always had the ability to block the access of users who shared copyrighted material. Since they did not block this, hence this argument weighed against Napster. The second point was the infringer should have direct financial interest in the infringement. Though Napster did not had any direct interest, but since their business model was based on expanding number of users, again this argument was against the Napster, and the court concluded even the claims of vicarious infringement on Napster. Over to Arvind.
Although fair use was the primary defense used by the defendant, the other defenses used by them were based on the Audio Home Recording Act and the Digital Millennium Copyright Act. Audio Home Recording Act, enacted in 1992, protected non-commercial users from copyright infringement liability when they make copies of digital musical recordings. The court dismissed the arguments that these protections could apply to Napster's users, since a computer and its hard disk do not have their primary purpose of making audio recordings, and the sounds saved to a computer drive are not within the definition of a digital music recording, which were discussed in the law. Digital Millennium Copyright Act, enacted in 1998, offered a safe harbor from liability for online services that provide access to computer network systems on which a user may ultimately commit a copyright infringement. The court agreed with Napster that the DMCA provisions could protect Napster itself from liability for the infringements committed by its users. The court held that the safe harbor issue would be explored further at the trial. Next slide, please. The preliminary injunction from the district court had instructed Napster to stop the exchange of the copyrighted data on its platform immediately. However, the Ninth Circuit did order a stay of the injunction as it placed the entire burden on Napster. Recognizing that Napster's system did not automatically verify copyright ownership, the court found that it was the plaintiff's burden to notify Napster of any infringing files on the system. However, the court noted that the Napster must actively police the system. Eventually, when Napster struggled to comply with the demands of the rewritten injunction, the court ordered the service shut down until it could be 100% effective in complying. Next slide, please. The case was very pivotal in determining how copyright law applied to digital media sharing. It put an end to any speculation that such services could facilitate copyright infringement but still shield themselves from any liability due to the fact that it was the users that chose to share illegal copies of protected works. It was affirmed that a party is liable for infringement if it has a knowledge of, material contributes, or financially benefits from another party's infringing activities. Next slide. Issues related to peer-to-peer file sharing were again litigated a few years later when a successor company to Napster, Grokster, was sued by MGM Studios. Several file-sharing networks surfaced in Napster's wake, many of which faced their own legal challenges over infringing material on the network. These file-sharing networks paved the way for the streaming media platform that today dominates the music market. Thank you.
Where are the references? You're not included references?
Hello. Yes, sir. So
Saurabh?
we have submitted a full term paper, which is a docs document in which we have explained each issue in more detail, and all the references have been put in that.
Okay.
Yeah.
Thank you.
Thanks.
Group number 18.
Yes, hello sir. So I'll just present my screen now.
Good morning, sir. Can you please confirm if I'm audible?
Yes, you are audible. You are all audible.
Sure, thank you.
Okay, you are group number 18, right?
Yes, sir. Yeah.
Okay.
Is my screen visible?
Yeah, it's visible.
Yes.
All right. So I'll begin now. So good morning, everyone. Good morning, sir. Today, our group 18 is going to present the clash between the National Biscuit Company versus Kellogg Company in the year 1938. So my name is Maya, and I'm going to give a brief overview of what we're going to present today. So in 1938, the National Biscuit Company filed a lawsuit against Kellogg Company, where they complained that Kellogg Company has violated that trademark and has has violated competition laws. This was when Kellogg Company started to manufacture a very popular breakfast cereal that National Biscuit Company used to manufacture, called the shredded wheat, which was a best-selling cereal. So this is how it went. After National Biscuit Company filed their lawsuit, court proceedings indicated and they were ruled in favor of Kellogg Company. This is because the patent for shredded wheat had expired and Kellogg Company had taken advantage of that, and henceforth Kellogg Company was allowed to manufacture the cereal.
I'm not able to see the face of fourth group member.
Sir, I won't be able to switch on my camera, unfortunately, because I'm traveling right now.
Okay,
Sorry
okay, no issues, no issues.
Right, and Just to wrap up the overview, this case was very important and considered a turning point in the US trademark opinion roots. After this act of 1938, there was a tremendous state of flux in the trademark laws, and the Supreme Court also decided to indoctrinate this case into the revision of the Lanham Act. So now I'll just give over to Sange so she can explain the historical background.
Yeah, so now we'll take a look at the historical background to gain a better understanding of the case. So, shredded wheat was manufactured from boiled, dried, compressed thin shreds of whole wheat, which are then baked, packaged, and sold to the consumers, forming a versatile breakfast cereal. In 1908, a company named Shredded Wheat Company commercialized shredded wheat. Now, this company had issued patents in 1895 for both the shredded wheat and on the machine. Moving on to the next slide. Company started manufacturing shredded wheat cereal in 1912 after the patents had expired. So after the shredded wheat company objected, Kellogg had stopped manufacturing in 1919. In 1927, Kellogg again resumed manufacturing shredded wheat, and this prompted a lawsuit from the shredded wheat company. This lawsuit was then settled. Now in 1930, the company Shredded Wheat Company was acquired by Nabisco, which is the National Biscuit Company. Um, so in 1930, after the acquisition, Nabisco again sued Kellogg both in Canada and in the United States for unfair competition. So Shaurya will continue.
Good morning, everyone. So now I'll explain what the conflict under discussion is. So in this case, the plaintiff is the National Biscuit Company, and they had filed a lawsuit against the Kellogg Company for essentially three major reasons. Number one was that they believed that the Kellogg Company had actually leveraged their goodwill and the brand name of the shredded wheat cereal to create more publicity for themselves. That's one. Number two, it is they also objected to the picture on the Kellogg box, which consisted of the pillowcase shaped cereals dipped in milk. Now, this picture was first utilized by the shredded wheat company initially, but they had also sued the Kellogg company for having used the same. And lastly, they believed that the entire proposition was essentially Kellogg company was essentially just trying to pass off their own cereal as that of the first company that had manufactured it. Next slide, please. Maria, can you please mute your mic?
Yeah, just give me a second.
Sure, thank you. In this case, what National Biscuit Company had failed to do was to realize that they had the attempts that they had made to register their trademarks under the patent laws were not actually successful, and the U.S. Patent and Trademark Office had actually rejected their application. So this was something that was unknown to National Biscuit Company when they had filed the lawsuit, and in response to this, Kellogg Company had put in their defense, and they denied the plaintiff's claim that they had exclusive rights to the shredded wheat cereals, and they believed that that manufacturing such pillowcase shaped breakfast cereals was something that anybody could do, since it was not protected by the trademarks because of their expiry. And they also claimed that they made every attempt possible to differentiate their product from the other ones, and this differentiation was important because this helped them to win this case essentially later on, as we'll show later. And they also claimed that they had free right to manufacture the cereal, which was unprotected by the patent. And the way they argued this was by saying that in order for them to capture a sizable market share, they would necessarily need to kind of reinvent on the existing product that had existed in the market, and then bring their own new form of packaging and flavors to it, and essentially to capture a market share. Next slide, please. Yeah. So they also assumed Kellogg Company also in their defense said that the shredded wheat, this phrase or the term was pretty generic as it was not protected by the trademarks, and also they believe that that the plaintiff does not reserve any exclusive right to it. This is very similar to the case, the use of the word Maggie in Indian context. We use Maggie for almost all the other noodles that we have. Essentially, they wanted to we use the term Maggie generically. So essentially, the Kellogg company ran on the same narrative that that the shredded wheat was essentially a product that was known to everybody. So there was no copyright over the term in and of itself, right? And lastly, and they also pointed out the original patent had expired, which essentially helped their case a lot. And they also pointed out that the shredded wheat, the term shredded wheat, essentially encompassed the machinery as well as the raw material which was used to manufacture the cereal, and not necessarily the end product in and of itself. So this proved that this is what their claims were essentially of the Kellogg company, that the plaintiff did not have the exclusive rights for using the name. Next slide, please, Mario. Uh, so in response, the plaintiff said that even if what the Kellogg company was saying was true, and these guys had manufactured the product after after the patent had expired, even then they did not have the right to manufacture it because this was lost due to the delay in the communication, essentially. And but however, this was turned down by the Supreme Court, and they ultimately concluded that in order to resolve this case, what was the resolving clash was that they needed to prove the Kellogg company needed to prove that they had sufficiently differentiated their product from that of the competitor, and so this was claimed to be a fair metric for them to decide on whether or not the Kellogg company deserves to be charged on this in this case or not. So after carrying out a very thorough investigation of all the facts and all the product parameters, it was concluded that it was indeed differentiated by the Kellogg company. The way they have done that was to look at the size of the individual cereal flakes, and the size were essentially two-thirds as that of the original product. This, as well as the fact that all of the flakes had a certain Kellogg brand on it, right, as well as the clear brand name and the trademark of the Kellogg company was used throughout the product, and therefore it was clearly differentiated from that of the competitor. So the Supreme Court in the end concluded that it was that the Kellogg company in fact had used the goodwill, but this goodwill was not used in an unfair way, and this was only done to attract a fair market share in the market, and thus they were declared not guilty by the Supreme Court. Next slide, please.
Okay,
Right.
so I'll
So
take over now.
talking about the verdict and the Sure, Naman,
Okay,
go
so
ahead.
I'll take over now. The slide is on court verdict and opinions. So what happened was in a 7-2 opinion written by Justice Brandes, the Supreme Court rejected Nabisco's lawsuit and thereafter allowed Kellogg to manufacture the shredded wheat cereal under the trade name of shredded wheat. And on the contention of shape of the cereal flakes, there was enough evidence that was provided that the pillowcase shape was an integral part of the function of the flakes. And since the patent had expired, Kellogg Company now had the right to copy that shape. And on the contention, which was like the second thing that was contended in the courts, on the contention of a picture of the product sold in a bowl of milk, it was concluded that the brand name of Kellogg on each flake and carton was enough to differentiate it from that of the National Biscuit Company. Hence, there was no fraudulent impersonation that was found by the court with regards to Kellogg cereals. And on the third point of contention, that was about the use of the name shredded wheat, it was concluded that the term in itself was generic and that it was non trademarkable. Next slide, please. So, what were the subsequent developments and the consequences of this whole lawsuit? So this case was somewhat instrumental in shaping the philosophy of trademark and patent infringements in subsequent cases by highlighting some of the fundamental aspects of patent and trademark laws. This is a lawsuit that was fought in the early 20th century, and it served as a base to the functionality doctrine, which stated that intrinsic functional designs are not protected by trademarks and unfair competition laws, and it was emphasized that this would prevent new competitors from launching and so as to like attract a sizable market share for rival products. Later, what happened was that the US Department of Justice decided to codify this decision by means of the Lanham Act, which prohibits patent and trademark infringement. The most notable amendment was that of inclusion of provision of allowing free use of product designs not covered by active patents by the public. Next slide, please. So these are our references.
Okay, who is the plaintiff and who is the defendant?
So the plaintiff is the National Biscuit Company and the defendant is the Kellogg Company.
What is your title of the term paper?
It's Nabisco versus Kellogg.
तो Kellogg पहले आना चाहिए बाद में.
Kellogg is the defendant, so we kept it second.
तो डिफेंडेंट का नाम फर्स्ट होता है और इट इज द सेकंड नेम वर्सेस.
The second.
It should be known as National Biscuit Company versus Kellogg, or the way you have written it.
So we have written it the National Biscuit Company versus Kellogg, and I think it should be that way because the National Biscuit Company
But
is
in
the
your first slide, you look at the first slide.
So so I think we when we submitted the term paper, we actually wrote it as Kellogg versus Nabisco, but then we changed it.
Okay, thank you. Good.
Thank you.
Okay.
Group number 19. Group number 19, are you there? Group number 20.
Hello.
Hello.
Sir, group 20 is here.
Okay, you may start the presentation.
Just a second, let me confirm my other two members are there.
Okay.
Yes, we can start.
Okay, start.
Yeah, sir, I'm sharing this.
Group number.
Is it visible, sir?
Yes, your screen is visible.
So our case is on Arsenal FC versus Matthew Reid. It's an trademark infringement case.
Okay, 1 minute, 1 minute. There are 3 members only.
Yes, sir.
Okay. Okay, please switch on your cameras.
Okay. Just a second. Yeah. So may I continue?
Yes, but only 2 members are visible. Where is the third one?
Sir, I cannot switch on my cameras.
Okay, that's not an issue.
Okay.
Thank
So
you.
our topic was Arsenal FC versus Matthew Reid. Matthew Reid.
Vikram, you're mute.
Vikram, you're not audible.
You're all muted, I think. Vikram, who is speaking right now?
Yeah, sorry, sir. Sorry, sir. I was.
Vijay.
I'll start it talking.
Who is speaking, Vikram?
Yes, sir.
Okay.
Yeah. So our topic was Arsenal FC versus Matthew Reid. It's an trademark infringement case. And so talking about the background of Arsenal, it's a renowned football club. It's also known as the Gunners, which is the other meaning of Arsenal. And part of their business, they use the word Arsenal merchandise, the Arsenal Gunners, and the device they used to make the cannon device. So Arsenal have a four registered trademark on their on of their own. So the first trademark is for the word Arsenal, and its registered number is 1383343. It was registered in May 1989, and the other one was the Arsenal Canon device. It was registered It was registered on June 18, 1989, and the third one is the Arsenal Crest device, which was registered in June 18, 1989, and the final one is the Arsenal Gunners, which was also registered in July 1989. So the Arsenal Football Club was a Matthew Reedson trademark infringement case, which is concerned about the sales of merchandise of the Arsenal Football Club. So talking about the case details, as I told earlier, it is an famous football club which was founded in 1886, and the club generates a average revenue of around 381.7 million euro, which was recorded data of 2010, and it includes other businesses which are which also include the selling of merchandise product, and because this case was mainly based on the merchandise. So Arsenal FC, as I told you earlier, the Arsenal own the trademark of their name, the word Arsenal. And so the Matthew Reed has been selling football merchandise with the Arsenal FC mark near Highbury Stadium in London for 30 years. So at the stalls there were disclaimers stating that the product were not official. Few product were official and labeled them separately. So the Arsenal Football Club filed a case against Reed in 1999 in January. They alleged Reed that he had done a trademark infringement and committed a passing off. But as the as on his stalls, he has clearly mentioned that the product were not official, and a few which were official, he had labeled them separately. So the court rejected the passing off terms, and also when Arsenal could not prove that uh, dif- the customer could not differentiate between original product and the one sold by the Reed, as we have already mentioned on separately. So there was no use of the mark as badges of origin. He just used as the badge of allegiance and loyalty. Like he didn't say that these are the product owned by me and originated by me. He just clearly mentioned that he's selling it on they are not owned by him. So, in terms of trademark infringement, it is relevant to make clear that in respect of it is the product is the symbol is used as a just as a sign or just as a mark. So it was difficult whether the legal issue covered by national law, which is influenced by the first counseling directive 89/104 on December 21, 1988, to approximate laws of member states relating to trademarks. So later on, this proceedings were gone to Lady J in March 2001. So the Vijay will be carrying it for taking or no.
Hello. So, since the issue was, I hope I'm. Hello, am I audible?
Yes.
Since, as Vikram mentioned in the previous slide, since the issue was related to the construction of the trademark directive, and which could not be decided without a reference to the European Court of Justice, ECJ. So the judge asked for questions to the ECJ for the analysis for the on the case, and So it was concluded by the judge that since the Arsenal have not appealed against the finding, and also Mr. Reid also contended that the Arsenal trademark was invalid, as Vikram mentioned that the witness answered that they knew where they have bought it or where the product origin is. So Arsenal couldn't prove that the buyers are confused about the origin, and so there is no point of where the product is origin. So the trademark infringement doesn't hold, and the judge concluded over in the first judgment that it's not a trademark infringement, but he counseled the ECG regarding the matter with questions. And uh, as we go in the next slide, ECJ answered some points regarding the analysis. So the point number 42, ECJ mentioned that regarding the Article 5 of the directive entitles that the trademark proprietor to prohibit any use of the third party in the course of trade of a sign identical to a trademark for goods for those which the mark is registered, or whether the right of prohibition presupposes the existence of a specific interest of the proprietor as trademark proprietor. So this was the actual concern as well, like if existence of like the specific interest of proprietor matters or not, or it is presupposed, or the right of prohibition is presupposed in that manner. If it presupposed, then the first judgment could be in concern. So the judge again mentions in the paragraph 66 of this judgment that the judgment was not correct. The crucial difference between Mr. Zre's and the second alternative is basically the interest of proprietor's trademark right and whether that interest is liable to be affected. So they did mention that the competitors were taking the unfair advantage of the reputation of the trademark, as all the fans and everyone were interested into product because it was connected to the Arsenal Arsenal label. So it does raise this concern. Can we go to the next slide? So after that, ECJ mentioned this important 2 points, which concludes their analysis. Is that having regard to the presentation of the word Arsenal on the goods shows the interest, so at issue in the main proceeding and the other markings on them. The use of that sign is such as to create the impression that there is a material link in the course of trade between the goods concerned and the trademark proprietor. That conclusion is not affected by the presence on Mr. Reed's stall of notice stalling that the goods at the issue in the main proceeding are not official Arsenal FC products, which was not mentioned by the Mr. Reed and was accepted by the Mr. Reed in I think the first judgment as well. And there is a clear possibility in the case that some consumers, in particular if they come across the goods after they have been sold by Mr. Reed and taken away from the stall where the notice appears, so there is no notice now, so where it origins, now the sign may get misinterpreted or like interpreted as a sign designated from Arsenal FC. So in a original case, the witnesses mentioned that they knew where they are buying from, but if the consumer or the people who have bought it give the fan memorabilia to someone else or their friends or family, they will not know that where it came from, like what's its origin of, and if there is any issue, this there have been what you can say, the events where the consumers have complained to the Arsenal FC directly even though the goods were actually been brought and they were not knowing where the goods came from. So this confusion did happen, and this was concluded in the analysis by the ECJ, and disregarded the decision against the judgment, first judgment. So going to the next slide. So what is the legal relevance? So since this decision is special relevance for the trademark law in the view of trademark directive, like does this prohibition presupposes interest, and so it pointed out in the analysis that it does a specific so the specific interest of the proprietor does matter as a consequence of the essential function. And for the applicability of the law, there has to be first a specific interest by the owner of the registered trademark, uh, which was mentioned here. And therefore, this special interest has to concern an essential function of the trademark. In this case, the ECJ pointed out that the essential function is the guarantee of the origin, uh, which was in the concern when some labels were taken off from the product. Can we go to the next? I think Rahul will take it from there.
Yes, yes. Now I will take
We
over.
have 2 minutes
Next slide,
left.
please. Why, uh, why they went to ECJ for appeal? So, first, Mr. Reed's goods were very identical to Arsenal. So, if the tag or the swing ticket was removed, people were not able to differentiate between what was Arsenal's product and what was Mr. Reed's product. And next, if I am buying the product, I know where I bought it from. But if I pass it to someone like my friends or my family, I don't know where the product came from. They don't know where the product came from. So people who are not buying it directly from Arsenal, if they are using their product and they are having some issue, some problem, they are directly going to Arsenal and not going to, as Vijay rightly mentioned, that they are directly going to Arsenal and saying their problem out loud. But they are, but the product was not Arsenal's. The product was made by Mr. Reed, and thus there was an issue. Next slide. And thus, as the decision was taken by High Court, but the European Court of Justice uh, gave the decision that gave the guidance that the European Court of Justice, the European Court of Justice said that uh, Mr. Reed's product and Arsenal's product are matlab, they are very different from each other. They are so. One second, can I? So the High Court said that Court of Appeal, which was above the Court of England, so that was only the court from where the judgment can be held, and European Court of Justice's guidance was taken into consideration. And now I think Vijay will take over.
In this, the High Court appeal year, month, etc. Nothing is given here. You have not mentioned all these things in the appeal and final conclusion of the High Court. Not very clearly coming out.
So
Divijay, go to the
in
previous
the end,
slide.
it was from the guidance of ECG, it was concluded that
नहीं 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 जो एक लोकल कोर्ट ने जो 2002 में दिया था जजमेंट अपना, उसके बाद में अपील क्या हुआ, किसने क्या किया, वो कहाँ बताया है? You have not shown that. You have not mentioned the years and all that. Details are not mentioned.
so it was mentioned that in December 2002 they appealed.
appeal 2002 वाला है, that is appeal. Huh? The case came back before the judge in December. No, it is before the judge. The same judge cannot hear the appeal. No? So there is some confusion at some end in your the thing. ये जो आर्सेनल कंपनी ब्रिटिश कंपनी है, कहाँ के आर्सेनल?
सर लंदन, यूरोप.
लंदन, यूरोप में ब्रिटिश हुई ना ये कंपनी?
यस सर.
और जो रीड्स है ये कहाँ की है?
सर ही इज ए लोकल वेंडर.
वो भी यूके का ही है?
यस सर.
तो जब दोनों ही यूके के हैं तो उनको यूके की कोर्ट से यूरोपियन कोर्ट में जाने की क्या जरूरत थी?
सर क्योंकि डेफिनेशन ऑफ द ट्रेडमार्क मतलब सॉरी कंस्ट्रक्शन मतलब ट्रेडमार्क इन्फ्रिंजमेंट रिलेटेड क्वेश्चन था, तो कि बेसिकली इन दैट केस कि
यूरोपियन यूनियन में देयर आर सो मेनी कंट्रीज है ना, 26 कंट्रीज प्लस हैं.
Yes,
तो अगर एक कंट्री का इंटरनल मैटर है, लोकल कोर्ट सब कंट्रीज में होती है ना.
yes,
तो जो एक लोकल कोर्ट में गया एक मैटर, उसके बाद में जो भी उसका आर्ग्यूमेंट होगा सब लोकल कोर्ट में होगा, अपील भी लोकल कोर्ट में. यूरोपियन कोर्ट क्यों गए ये लोग?
सर उसमें ये मतलब कंसर्न था कि जो मिस्टर रेड ने यूज किया ट्रेडमार्क वो सिर्फ बैज ऑफ सपोर्ट या लॉयल्टी की तरह है, या डज इट आल्सो सम वे इन्फ्लुएंसेस द origin, like you know, like it creates a connection to the origin, and if it creates, then the trademark would be infringed. बट उन्होंने फर्स्ट में ही ये कंक्लूड किया था कि ट्रेडमार्क इंफ्रिंजमेंट इज नॉट देयर, द प्रोडक्ट्स वर सोल्ड एज basically badge of loyalty, and
You are not responding to what I asked. I asked you when the plaintiff is in UK, London based, and the read जो है that is also London based. So they have to go for the local court and the High Court of British High Court and British Supreme Court. Why do they go to European Court?
sir,
Sir, they went to ECJ for guidance only. So their orders were not
सर उसमें ऐसा लिखा था कि इशू ऑफ कंस्ट्रक्शन ऑफ ट्रेडमार्क डायरेक्टिव व्हिच कुड नॉट बी डिसाइडेड विदाउट अ रेफरेंस टू द ECJ, so they had to refer, like if it is regarding to the trademark directive.
Okay. Right. Thank you.
Yes.
Thank you, sir.
Thank you, sir.
Group number 21.
Sir, group 19 is present. Can we present now?
Okay, start.
Okay. Sir, can you see the slides?
Yes, we can see the slides. No. We are seeing yes, we are seeing it now.
Okay, sir.
And please switch on your cameras on the presenting group members.
Okay, sir. So, sir, actually, it is saying that you can share, you can share your video when you are done screen sharing. So, other group members uh, can open the camera, I think.
No, simultaneously it can be done, and your presentation is not visible to us.
Okay.
And I'm able to see the camera of only two persons.
So, hi everyone. I am Ratnesh, and the topic of our presentation is the case study, the IP infringement case study, case of Intel versus VSLI technology, and this is of just this year, 2021, and so in our team we are four. I am Ratnesh, and then Yatik and Ujwal and Mahendra is also there. So entry number is also written on the slides. So this will be the structure of our presentation. So this will be the sequence. So uh, uh, so introduction. So as everybody knows that Intel is a leading manufacturer of microprocessors in the world. Uh, it makes chips also, and it makes chips which are used in laptops and desktops. And then BSLI technology is actually a company which makes integrated circuits for specific uses. So what happened is in April 2019, VSLI technology acquired two patents from some other country, two patents from some other company. Uh, Actually from a Dutch company called NXG. So after acquiring the patents, VSLI technology found that its patents are it's the same technology which are being used by another company called another company Intel. So they filed a complaint against Intel. So Intel Corporation. So Intel, everybody knows that it is American multinational company, and it is headquartered in Santa Clara in California. It is world's largest semiconductor chip manufacturing company by revenue, and it's the developer of Microsoft's x86 series of microprocessors, and which is used in personal computers. And this company is actually ranked 45 in Fortune 500 list of corporations of United States. Now VSLI technology. So uh, VSLI technology is also an American company, and it is also based in California itself, and it is in San Jose in California, and it makes integrated circuits. Its business is actually making application specific integrated circuits, and then selling them. So actually what happened is that when VSLI technology filed the complaint, and then it was in 2021 by the jury, it was awarded 2.118 billion. So Intel has to pay patent infringement damage of 2.18 billion. It happened the uh, so from here Ujjwal will be presenting.
Ratnesh, next slide, please.
Background of the case. Since the launch of Intel 4004, the introduction of pipeline has significantly changed the CPU market and better use of CPU hardware. So before the launch of Intel 4004, CPUs are not used to be as powerful and as productive as they have been. And like Intel can be say is the pioneer of the CPUs, like CPUs innovation. In November 2015, Intel launched their new system called Skylake, new system which was called Skylake processor, which have a specific technology called Intel Speed Shift technology. In 2019, VLSI Technology filed a case suing Intel for breaching those patents held by them, US 63665 b one and US 66387 b one. According to VLSI, Intel Speed Shift technology clearly violates the stated patents which describe processors self-monitoring their use and scaling their clocks and power consumption as needed. So like the processor will determine the processes that are running on the processor are CPU heavy or not, or they manage the power usage according to that to save power or to increase the power and increase the speed of processor. Next slide.
Just 1 minute, 1 minute, 1 minute. In the second line, change the CPU. CPU is a capital CPU or a small CPU?
Okay. Like all CPU, like it was an
नहीं नहीं
innovation.
नहीं 1 minute. It is a small CPU have written in small letters, and उसी line में
It is actually capital CPU, sir. We are sorry for that.
better use of CPU hardware, तो CPU capital letters में आ गया, इधर small letters में आ गया.
No, sir. It is actually capital letters.
Capital. Sorry, sir. Sorry.
Both are capital letters.
So you should not be so casual about writing anything. Okay.
Okay, sir. Sorry.
चलो चलो आगे चलो.
Next slide. VLSI acquisition of the patent. So VLSI originally did not own any of those patents. So the patents was all by two companies, the Freescale Semiconductor and the Sigmatel. Like the Freescale got the patent in 2012 and the Sigmatel got the patent in 2010. Freescale brought Sigmatel, so the Freescale got both of the patents after acquiring Sigmatel, and then in turn Freescale was bought by NXP, so that they got the ownership of both patents. And in 2019, NXP was acquired by VLSI, so in turn VLSI got the patents. So we on acquiring the patents, VLSI lawyer Morgan Chu and Ariel Menendez said that the patents cover inventions that increase the power and speed of the processor. That are the key elements of the competition. Like the processor are basically judged on like their powers and their processing speed, and that those patents that they acquire, Intel was breaching them to like increasing their power and not paying any royalties to them. Next slide, Ratnesh. Breach patent. So the patent US 63652B1 is a method and apparatus for controlling power consumption of an integrated circuit, include processing that begins producing a system clock from a reference clock based on system clock's control signal. Next patent that they breached was US 6633187B1, and method and apparatus for enabling a standalone integrated circuit include processing that begins establishing an ideal state, hold at least a portion of standalone circuit in reset condition when a power is appropriately coupled with a standalone circuit. So that one is for the patent number one is for increasing the speed of the processor, and the patent two is monitoring the usage and controlling the circuit so that the circuit doesn't use more power and remain efficient. Next slide. Case outcome. On March 3, 2021, a federal jury in Texas told Intel to pay $2.18 billion to Verify Technology for infringing its patents related to chip making technology. Intel pleaded for appeal. The jury rejected Intel's denial of infringing either of patents and its argument that one patent was invalid because it claimed to cover work done by Intel engineers. The patent had been owned by Dutch chip maker and NXP Semiconductors included, which would get a cut of any damage award. Next. Significance of the case outcome. Jurors on March 2 awarded VLSI 1.5 billion technology, roughly 11,000 crores, for the patent infringement number one, and 675 million for the second patent infringement, which were once owned by NXP Semiconductors, like which later VLSI acquisition. The amount makes it the second largest patent damage ever awarded, like in any case of patent infringement. And it's for the third time US told the defendant to pay damage over 2 billion. The jury recognized 1.5 billion damages for one payment and 6.5 billion. From here, Yatik will continue. Yatik.
So they are the top 10 patent awards by the US jury. So as you see, Intel versus VLSI technology is the second largest uh, uh, patent infringement case, and I awarded 2.1 billion of loss by the Intel technology to VLSI. So next slide, please.
2 minutes left.
Okay. So we researched about this case, and we found that this is a this is very famous and most talkative case currently in 2021 and 2020. It's as we know, Intel is a very big company, and it lost so much money in the past few years as it's a deal with Apple for getting its Intel chips terminated, and now they lost 2.1 billions in this patent trial. So we thought it will be a great idea to show this case. This case is not only famous in USA, it is also famous internationally. Like in India also, we saw many newspaper articles and many articles on Guide 360, NDTV, etc. Next slide, please. And there is another case just after the decision came out of this infringement case of $2.18 billion. Intel defeated VLSI technology in another billion patent trial, which is of worth 3.1 billion. But VLSI technology has pledged against this trial. So we will see what happens after in this trial of $3.1 billion. So Intel actually claimed against the trial of $2.1 billion where again in another jury. So a different Valco jury ruled out in Intel's favor on April 2021 for another claim of $3.1 billion. The conclusion of this trial is VLSI technology won the case on 2nd of March 2021, and Intel has to pay $2.18 billion to VLSI technology for the settlement, which is the second largest amount ever paid in patent settlements till now. It was a great deal for VLSI technology as they didn't own any of those patents before 2019, and they got in 2019 and won a $2.18 billion case just in 2 years of getting those patents. Next slide. So the other references we researched from Bloomberg and various other websites to find about this case.
So who is the defendant? Tell me. In this case, who was the defendant?
Defendant was Intel Technologies.
अच्छा, और आपने जो है वो टाइटल देखें टर्म पेपर का जरा सा. पहले whose name should come first? VLSI or Intel? हाँ?
VLSI should have come first.
तो उल्टा क्यों लिखे हो? चलो उसको ठीक करो.
Yes sir. Yes,
okay. ठीक करके दोबारा भेजो.
Yes sir.
Okay sir.
चलो. Okay. Thank you.
Thank you. Thank
Good.
you,
sir.
Good.
Thank you, everyone.
Thank you, sir.
Group number 21.
Yes sir.
Group number 21.
Yes sir.
Yes, start presenting.
Is my slide visible? Yes, it is visible. So hello everyone. So today we are going to present our term paper for MSL 802, and we will be discussing on the case Kentaro versus Amit Rohtak and eBay. So Pradyuman will begin by the abstract of the case. Pradyuman, are you there?
You are on mute.
Sorry. Yeah. So this case ran between December 21, 2016 to January 18, 2017. This was filed by the chairman of Kentaro Systems, Mahesh Gupta. As you all know, Kentaro is a huge presence in the water purifier systems market, and it was filed against Amit Kotak, defendant number one, who manufactured and traded water purified, which were deceptively similar to those designed and uh, patented under design patents by Kent, and eBay India Private Limited, who through which he sold the RO systems. So they were being charged as aiding and abetting this infringement of Kent's IPR by being an intermediary. Satvik will take it from here.
Good afternoon, everyone. So, coming to the introduction of this case, Kantaro System Limited, and its chairman, Mr. Mahesh Gupta, are water purifier manufacturers and had several designs registered uh, for their aesthetic appearances. And Amit Kotak is also a manufacturer of water purifier systems whose appearance were similar to the water purifiers of Kent, and their goods were also being sold at the online e-commerce shop eBay. The defendant number two, the the plaintiffs, before initiating this suit, had a permanent directive to eBay, asking them to block all of the URLs. So coming to next slide. So coming to the response, eBay responded to plaintiff's claims by stating that they had removed all the products, but still uh, the plaintiffs discovered that a large number of their products were still being sold on the website, and hence the first suit came up and the summons were asked to block all the URLs on which these products were being sold. The court judgment began on 18th January, and uh, and came forward that the defendant one had no objection to the suit claim initiated by the plaintiffs, as long as they give up their claim for the damages and accounts thereafter. And therefore the single judge passed a decree in favor of plaintiffs and against the defendant number one, and directed both these parties to bear their own cause. Ashish, carry on.
Yeah, so now I'm going to discuss on what is intellectual law information available in India. So firstly, what